May I the question? Respect to action number 1, my lord. No, I want to withdraw this petition.
1.
Well.
Okay. Upon instructions, Mr. A.K. Hussain, Learned Counsel for the appellant, seeks to withdraw this appeal. There is allowed, matter stands dismissed from withdrawal.
Wait, please, your lord.
Just of minutes.
Wait. My lord, part 2 hearing list, my lord, 7 and 8. One is the date reference, my lord, which is a daily list, I'm sorry, daily list, my lord.
Daily list.
7 and 8, my lord. One is the date reference and one is the criminal appeal against the sentence, my lord. So may I pray, my lord, that there are 36 witnesses here in this case. It will take much time. And the prosecution will start most probably in this case because there is a date reference also. So may I take 2 weeks time so that I can go through thoroughly everything, my lord?
2 weeks. Mr. Das,
Dada,
both sides are duly represented. On the fair Midwest A.K. Bhair and counsel for the respondent. List after 2 weeks.
deeply obliged.
Wait, please, your lordship. I beg to mention item number 9. Conducting counsel, senior counsel A.M. Bora did not come to the court today due to some personal difficulty. Kindly fix the matter after 2 weeks.
No, just wait here. I will read the record. Item 9. Okay. 21.
21 of this month. Lordship. This month?
This month.
Yes, your
Just
lordship.
after 2 weeks as paid for by Learned Counsel for the appellant. What's his representative?
Much obliged. May I please, your lordship. With regard to item number 10 to 13, my lord, I'm led by Mr. Senior Advocate J.K. Mishra in this matter.
It's not good for us. Both sides are duly represented. List these matters before. In a bench without one of us. Which is creative. Ten to 13.
May I would like to mention regarding item number 14, 15, and 16, lordship. May I pray for adjourning the matter for today, lordship? Next week, any. 14, 15, 16 arising out of same day.
You have taken consent of the other side?
Yes, lordship. We have given sleep, adjournment sleep also.
Okay. Both sides are duly represented. The fair midday Mr. A. Ahmed Counsel for the appellant. List after
1 week.
list after a week.
Obliged.
Supplementary of the list, item number 18 for orders.
Here this interlocutory order, in interlocutory application has come up for consideration of bail prayer of Konoklata Das, Lordship. Here two persons were convicted. Mother and son were convicted under section 302 for life imprisonment. And we have preferred the interlocutory application for the mother only, on the ground that there is no material against her and considering her age and ailment, Lordship. If your Lordship see the FIR that your Lordship will find at page 4.
Paper book.
Paper book. This FIR was lodged on 11/11/2014 and date of incident is 10/11/2014. And on the date of incident itself, the appellant, one of the appellant, that Ratan Das, he informed the police about the incident. That your Lordship will find page 6. And which was registered as UD case, and on the basis of that investigation was investigation started.
But despite the age, you see, there is evidence here that the mother-in-law dragged her by the hair and tried to pull and push her, and thereafter all this incident happened.
No,
So
regarding
her
that,
active
Lord-
participation in the assault on the daughter-in-law is there.
but here I am convicted under section 302.
No,
Now,
you see,
if your
302 is
lordship
there because there is a sequence.
Lordship.
What you call, the sequence which I understand is that the girl was ill.
Lordship.
Thereafter, her mobile was switched off. Then the parents of the girl, when they came to the village, they found that the girl was being cremated.
Lordship.
At that time, they stopped it. Initially, they did not want the girl to be taken for autopsy.
Lordship.
And then there is an allegation that the girl wanted to leave the matrimonial home. The mother-in-law dragged her inside. Then it came out that the girl committed suicide by taking Harpic.
Lordship.
So you see, everything happened in the confine of the house.
No, this is here, Lordship. If your Lordship see the first thing in the evidence of PW1, because I am convicted under section 302. If your Lordship see the page number 13 of the paper book, page number 13. The first ingredients prosecution has to prove that it is a homicidal death.
No, if it is homicidal, you would have informed you would have informed the police and all. But there was an attempt to cremate the dead body.
No, I have informed the police. The police has already deposed in this regard, PW8. Last line, your Lordship will find examination in chief. No definite opinion can be. Page 13, Lordship.
1-3.
1-3.
Dr. Singh.
Dr. Seven. Last line before cross. No definite opinion can be given regarding whether the death was suicidal or homicidal.
86.
So for first they have to prove that it is a homicidal death. Then they can be convicted under section 302. And apart from that, if your Lordship see the evidence of PW3, his evidence and cross, if your Lordship compare both, he has deposed for many things for the first time before the court, which is in the which is also admitted by the learned trial court in the judgment itself. And only material which I find, that is Harpic and the finding of the FSL report, which says organophosphorus. The difference between that only. And all the neighboring witnesses, they said, Lordship, their matrimonial life was peaceful and there was no torture. Only PW3, who is interested witness, he said about that for the first time. And the accused himself took the victim to hospital, and during investigation, no material was found against the present applicant for whom I am seeking bail. She was, Lordship, subsequently added as an accused under section 319 after recording the evidence of PW3. She was not charge sheeted. Although her name was there in the FIR, final report was submitted, and subsequently after recording the evidence of PW3, she was summoned as an accused. Because during investigation, there was no material against her. That your Lordship will find in the judgment itself at page 66, paragraph 2. where
Just
it
a
is-
minute, just a minute. Yes.
Here, if your lordship see the evidence of PW 5 and 6. They clearly say after the incident, the appellant, the one of the appellant, that Ratan Das, he took the victim to the hospital. And thereafter, the victim's family members were informed about 10:30 PM, lordship, 10:30 AM. And the brother PW3 says they arrived in the house of the appellants at 1:30 PM. And police also arrived 2 to 2:30 PM, lordship, on being informed by the appellant side. But the PW3 did not raise any objection or any complaint to the police officials, lordship. Only on the next day, he filed the present case. From the evidence of 5-6, your lordship will also find that the victim's family did not attended Shraddha ceremony after lodging the case.
Definitely.
Lordship.
But this FIR,
Lordship.
this was lodged by this Ratan Das.
Lordship.
Ratan Das is PW3.
No, Ratan Das is one of the appellant.
He is one of the appellant.
Yes, husband of the deceased. Initially, he took her to
No,
hospital.
Bikramjit Das, informed is Bikramjit Das
Bikramjit Das is brother.
is the brother,
Is the brother.
PW3.
Yes, PWC. Because in his cross-examination, he admitted that he arrived there at 1:30. Police arrived there 2 to 2:30 PM. But he did not make any complaint to them. And this is a conviction under section 302. So there cannot be presumption that within 3 years or that part cannot come. Actually. They have to prove each and every ingredient of circumstantial evidence.
No, when the dowry is alleged,
Lordship.
7 years of marriage, presumption is there.
No, that part is not here, Lordship, because conviction under section 302, 304 is not there. And my only prayer before Lordship is that the daughter who is in the house, there is no one to look after. Therefore, we have filed the application for mother only at this stage.
So that's. Now, my lord, my learned friend is relying on the evidence of PW 5 and 6, no? 5 and 6.
5, 6 and 8. Wait,
And 4 is also neighbor. My lord, when they asked the accused person, Roton, what happened? He says, I don't know. Not his wife is not fighting for his life and death, my lord, and he doesn't know. What does it indicate? Number one. Number two, my lord, she had a 3-year-old daughter. Presuming that she has committed suicide. Why suicide has been committed? Presuming that this is not a case of 302 and she has committed suicide by consuming her pig. Why has she committed suicide? Within 3 years of marriage. Automatically, my lord, the circumstance 304B will come. Now, that will be decided at the time of final hearing, my lord.
No, the two circumstances where we can consider the question of bail,
My lord,
that
yes.
she's a lady,
My lord.
number one. Petitioner is projecting that she is 70 years old. And the second part is that the young daughter of the victim, she's in the house, so that is the circumstances where considering the age of the
That I understand, my lord, but at the same time, this is a my lord, offense against my lord, society. If my lord, right now she is less than bail, my lord, some wrong message may also go to the society. They will renew their prayer, my lord, after some time. My lord. But right now, my lord, it is too early to my lord grant bail. And we have filed written objection also. My lord. Of course, objection is filed by somebody else, my lord, my colleague. There are evidence on record that she was my lord, tortured. She was subjected to torture. And PW3's evidence also says that those who are inflicted, those torture were inflicted on demand of dowry, money.
It is also on prosecution record that incident that there was quarrel with Ratan Das previous night, and in the morning she consumed poison also. So whether this lady can be implicated in that case, Lordship, that may have to see, because they are convicting me under section 302, and medical report is also silent whether it is suicidal or homicidal.
The medical examination, medical report cannot say whether poison has been administered or it has been consumed by herself.
Obviously, it cannot be ascertained by the postmortem examination. That will be determined through the from the facts and circumstances of the case and evidence on record. How the medical report can say that it is suicidal or it is homicidal?
The evidence of other witnesses also, it is not clear.
Seven to more over the transmission issue. For that, I can get it.
And about those contradiction in the evidence of PW 3 and 4, those were also confirmed through IOP, that PW 8 at page 39.
Just a minute. Just a minute. Yes, you were saying, what Mr. Ahmed?
Lordship, that contradictions at page 36, the evidence of PW8, page 39, your lordship will find.
Yes,
From 18 onwards, your lordship will find that Bikramjit has not made any statement to me regarding any demand of dowry by the accused, but he stated regarding the infliction of mental torture on his deceased sister by the accused person. Bikramjit thus has not stated to me that after coming to my house, her sister was not willing to go back. So these things he have not stated, lordship. And regarding that pulling part, your lordship will find question 23, page 14. That dragging part was also not there in his 161. Page 23, serial number. Therefore, during investigation, she was not an accused. After recording evidence of PW3, she was summoned as an accused. And when one judgment, Honorable Apex Court Lordship has granted bail considering that the appellant was 70 years old and not on merit, Lordship. Onil Ari.
the postmortem report gives the time of death.
Lordship. Postmortem report, Lordship will find at page 93.
Yes. Does it give the time of death?
It is there, Lordship. Time of death. It is not mentioned, Lordship, in the time of death.
It has to 12 hours. Time of death is about between nearly 12 o'clock in the on 10:11.
No, in the morning, also about 4 to 6 AM.
4 to 6 a.m.
Yeah. Because inquest report says 4 and FIR says 6:30.
The postmortem report is
Hmm?
the original postmortem report. It is not reported.
It is not given.
Time of death. Because
No, I'm trying to estimate it from that postmortem report where it says rigor mortis present. So rigor mortis, onset of rigor mortis differs from time to time, person to person.
climate,
Normally 6 to 8 hours after death,
yes.
and it will stay for 12 hours. Rigor mortis condition will stay almost for 12 hours. So therefore,
Sometimes it's 24 hours also. In some medical jurisprudence I have found. What is up to 24 hours is very easy.
24 hours.
If it is winter season and
Of course, it
the
depends on your
incident is
climate.
of November.
The existing
Now,
climate,
November.
present climate.
That's a thing. I can feel to the reading. But Sorry, so this is the state that say, also for the applicant. And Mr. D Das, then additional for the possibility of the state. Next point. This interlocutory application is filed under section 289, 389 CRPC for suspension of sentence. Next point. By the judgment and sentence impugned in the connected appeal. 10/2/2023. Passed by the Learned Sessions Judge Karim Ganj in Sessions Case number 49 of 2017. The applicant was convicted of committing offense under section 302 of the 34 IPC. And the applicant was sentenced to undergo life in prison, rigorous imprisonment for life, and to pay fine or rupees, also to pay fine with default stipulation. Next one. Brief, the investigation in this case was set on motion by an FIR dated 10/11/2015, lodged by PW3 before the Patharkandi police station, alleging that in the night of 9/11/2014, and occupation took place. No, this is not the FIR.
Page 4. This is lodged by the applicant. Investigation was started on the basis of this document filed by the applicant, and postmortem inquest, everything was done on the basis of UD case.
UD case.
UD case.
But this is 10/11/2015. Comma the son of the applicant, namely Das, who is also co-accused in this case, had lodged an FIR before the Patharganj police station, alleging that he saw his wife Jumki Rani Das, aged about 24 years, vomiting after consuming toilet cleaner, and that he, along with neighbors, took his wife to Patharganj Primary Health Center. And the doctors on duty referred her to Karimganj Civil Hospital, and that his wife died while they were crossing the north Patharganj rail gate. After the dead body was brought to the residence, and it is alleged that the paternal family of the deceased was informed. Accordingly, Patharganj PS UD case number 19/14. 10/11/2014 was registered. This was followed by another FIR by the brother of the deceased, namely Vikramjit Das, of the bracket PW3, alleging that the deceased, his deceased sister was tortured after marriage. And that at around 7:30 AM on 10/11/2015, the applicant and his son, the husband of the deceased sister, was fed poison by knife force, which resulted in her death. Accordingly, this FIR was registered as Patharganj PS case number 321/2014, dated 11/11/2014, under section 304. 304B IPC. In course of trial, the applicant was charged of committing offence under section 490A, 302, number 302 capital B, number 34 IPC. Prosecution examined 8 PWs, including the doctor who conducted the postmortem and IO of the case. And executed the following. Postmortem report with the exhibit 1, request report with the exhibit 2, dead body Chavan with the exhibit 3, addressing report exhibit 4, FIR exhibit 5, printed form of FIR exhibit 6, FIR exhibit 7, rough sketch map exhibit 8, charge sheet exhibit 9. The difference that reduce on the evidence. The Linux manager, cutting the day. On examination of the evidence of the partner. And that the prosecution had proved the charge under section 302 IPC, 302/34 IPC. And I ordered the sentence as referred herein before. Next paragraph. The learned counsel for the learned senior counsel for the applicant has made his submissions in for the purpose of suspension of sentence oblique bail. First of the prayer for suspension of sentence oblique bail is opposed by the learned deputy. By referring to the objection filed by the state. The learned deputy has placed reliance on the evidence of PW3, the informant, who was the brother of the deceased, wherein he had deposed to the effect that 1 week prior to his sister's death, the accused had demanded rupees 80,000 from his father. And on the next day, next day of demand, his sister was taken back home by the accused. And she was accompanied by the sister of the accused. Stop. He had deposed to the effect that 3 days prior to the date of incident, his sister was unwell and was administered saline. And on the day his deceased sister was not willing to go back to the matrimonial home, as the accused had assaulted, used to assault her physically, and with the help of their neighbors, they persuaded the deceased sister to go back to the matrimonial home. Stop. As for the PW3, when they reached the matrimonial home of the deceased, she found the sister had died, and that the accused and his family members were preparing to cremate his sister.
As per PW3, his grandmother had informed them about the death of his sister, and they were asked to go there immediately. At 10:25 a.m. and at 10:30 a.m., some unknown relative of the accused had telephoned them and informed that the sister had died of heart attack and asked them to come there. It is alleged that the accused persons were not willing to get autopsy done on the body of the deceased. And that the neighbors informed that the deceased was trying to go out of the matrimonial home in the morning, and that the applicant dragged her by her hair, and there was quarrel in the house, and after some time, the victim had died. So accordingly, it is submitted that not only there was a demand of dowry, but the victim was tortured for dowry, and subsequently she died by administration of Harpic. Accordingly, it is submitted that the witnesses examined by the prosecution had made consistent, had given consistent evidence leading to the only conclusion that the deceased was administered Harpic, and she had died thereafter. Okay, what is there in the postmortem report? What poison was found in the? No, it is there. Organic phosphorus or something is there. Organophosphorus. Now here is the difference. And what you call, here there is a question of doubt. I'll send you this. This is. It says Harpic is commonly used for toilet cleansing, contains hydrochloric acid, 10%. And now with butyl another water solution. Organophosphorus is an insecticide. It is not Harpic. Yes, thus. This is the composition of Harpic.
Yes,
and it is not organophosphorus. Organophosphorus is a insecticide. Therefore, if she is administered Harpic, then there will be corrosion in the gut and in the stomach. There will be corrosion.
but this is important. He says the accused says that she consumed Harpic.
I understand, but the postmortem report says that it is
Organophosphorus.
organophosphorus, and they
No,
are two.
And at the same time, it also says that was due to poisoning.
I understand, but you see, Harpic is a corrosive substance, whereas organophosphorus is an insecticide and therefore poison.
Exactly. That is why, Milord. When we have to rely on postmortem report, because
No,
this is
no.
this is
You
what I
see,
say.
it's not the case of prosecution. It's not the case of prosecution that poison was administered. Even the prosecution proceeded as if Harpic was administered.
No, that is only Rotondas's FIR says.
It's okay.
Rotondas's FIR, and then his case
But-
is registered as a UD case.
Yes, but you see,
Yes.
once an FIR is lodged, you know this judgment of the Supreme Court, which says that it will be the first FIR which will be the first information, and the others may be a what do you call the other FIR, maybe a corroborative material, but we are not on that. This
At the same time, Lord, if the first information report is cryptic one, that it cannot be treated as first FIR.
no, that
He
we don't
has,
know because
he may have given false information also regarding consuming of Harpic.
no, but the
Instead,
but you see,
she had consumed insecticides.
no, you see, that is okay. I'm not saying you are incorrect.
My lord.
But what I'm trying to find out is that how did the trial court arrive at a decision as to what poisoning was there? The poisoning was of what nature?
On the basis of FSL report.
Come to page 84, there is a discussion and decision, and then come to 85. The materials on record, para 17, page 85. The materials on record reveals that as per the information given by the accused Ratan Das, so and so he consumed Harpic.
Yes.
Correct. So this is the finding. And then because you see, then there's nothing, no discussion as to which type of poison is there. Come to page 87. Come to page 87.
No such.
Come to page 87.
My lord.
Sorry, 86 last line, then 87. It is worthwhile to mention that the defense took a plea with all clarity that the deceased ingested Harpic,
Yes.
which thereby shows that the accused persons have witnessed ingest Harpic and said nothing other than so and so. Whereas the perusal of FIR totally negates the plea of defense. As per FSL, the death was due to organophosphorus being a pesticide, and there is no such ingredient chemical in the composition of Harpic, which thereby clearly shows a false plea being taken.
Yes.
Correct.
Yes.
But now, this organophosphorus, if you are making out a case of murder, then
Murder.
this has to be found in the house. The police must make an effort to find out this organophosphorus and then link it with this, because if this substance is found in the house, otherwise, how do you connect that the administration of poison is in which manner? You understand my point which I'm trying to make, Mr. Das?
Madam,
If the death is by organophosphoric poison, that the accused has administered it, that must come somehow.
no, my lord, the only person, it was early morning, 6:30 morning, as per my lord, this FIR, open versus FIR. There may not be other person, and the deceased has already died. She was the only person to say, actually, whether she herself consumed or it was administered by the accused persons. So
No, she
that,
did not die. They took her to hospital and the case is that she died in the road.
no,
But
no,
the prosecution did
before
not,
reaching hospital.
no, but the prosecution did not dispel that.
PW
That she was never taken to the hospital. She was left to die in the house.
Madam.
That evidence is not there. Even the DW did not come and
How-
defense did not give any evidence that they took her to hospital. Even that is not there.
Madam, that your lordship is correct, that there is no evidence to the effect that the poison was administered to her. To that effect, that is why at the first instance, I submitted that it may come under section 304B also. After hearing. So I do not, it is not that no case has been made out against them. This is not a case of acquittal, madam. With all respect, I submit. Whether it will be 302 or 304B, but that will be decided at the time of hearing. And 304B also, my lord, provides for life imprisonment, minimum 7 years. My lord. That is why I opposed, my lord, the bill.
The applicant was tried as an accused person. Full stop. Therefore, comma, it appears that the appellant was on bail. No. The appellant was initially not proceeded as an accused person, and therefore she was subjected to trial on and from 16 to 2018. And it and the learned counsel for the learned senior counsel for the applicant has submitted that only after conviction the applicant was taken into custody. Next. Under such circumstances, comma, considering the projection made in this application that the applicant is a lady aged about 70 years. And also on consideration that she was initially not proceeded against as an accused person. The court is of the considered opinion that pending consideration of the appeal, the applicant herein be released on bail on furnishing bail bond of rupees 1 lakh with true surety of like amount to the satisfaction of the
Session just Karimganj.
satisfaction of learned Sessions Judge Hailakandi,
Karimganj.
Karimganj. Full stop. Next, the bail is granted to the applicant on the following conditions. That she would, that the applicant would give an undertaking in form of an affidavit that on that in the event the appeal is decided against her, she would surrender before the district jail,
Karimganj.
Karimganj, to serve the sentence. To stop. The applicant shall not leave the jurisdiction of Karimganj without giving prior information to the officer in charge of Karimganj police station.
That she is resident of under Patharkandi police station.
Patharkandi, okay,
Patharkandi.
Patharkandi police station. Patharkandi police station, by giving particulars of the place where he intends to go and the period of time she would be out of station. What other conditions can be given at this stage?
She will not leave the jurisdiction of
That
the
I have
court.
given.
And others, evidence is over, she is not like.
No, that's okay. That's what I'm asking you. These two conditions will be okay.
Passport আছে নাকি?
That is sufficient. Okay.
If she has any passport, I do not know, Miller.
If there is passport, there is no passport.
Yes, if the applicant has any passport, she would surrender the same before the court of learned Sessions Judge Karimganj. This application stands allowed.
May I pay one that Sessions case number may be mentioned also. Sessions case number may be mentioned in the order also.
Okay.
Sessions case number 49 of 2017.
No, this is already there in the top. In the beginning, when I gave about the sentence and all, then I have referred to the.
This is there, no problem. It is already there. Of course.
No, that is there. Only that what you call discussion part was just started. Or what is the case? Only that has been deleted.
That will do.
Huh.
How like? In main appeal that in main appeal probably that order will be.
Huh?
In main appeal probably one order will be required.
Ah, main appeal, heard so. As the paper book is ready. Let the matter be listed for hearing in the week commencing 11/9/2023.
How like?
But I have wanted in another court, Miller. I will be
Ah,
coming
yes.
back within 10
Yes, yes, yes.
minutes.
You are wanted or desired?
I cannot use that word. I wanted is a better word for before the court, my lord.
No, wanted, we only know
Desire
that
is-
posters and all wanted.
Some
No.
of the MPs, some poster are you seeing, man?
Huh?
Some MP, some poster are there, MP is missing one.
Missing. So that is why I wanted, I just.
That is what.
The latest item number 2 for hearing. Wait, is it? Should the appeal is directed against an order passed by the CAT on 19 December 2014. Respondents lordship 1 to 4 are represented by the senior counsel, Mr. Chaudhary.
But what is wrong in the order? It merely says that you'll have to give prescribed
Yes,
seniority, the correct seniority.
correct, but it has laid down some, I'll take your lordship to the paragraphs.
Okay.
lordship. Now, there are two issues before your lordship. One is the year of construing the select list, which year the select list will pertain to. Secondly, it's the year of allotment. Now, lordship, if I may take your lordship to page 51. From paragraph 28 of the judgment, I would just like to read out.
Just before you proceed, only one query. This is something I do not understand. We come to page 112,
Number 12.
112 of the petition.
Lordship, there is no 100.
There is no 112, my lord, that may be our affidavit, my lord.
Affidavit. Page 36, now 112.
Lordship.
Now, this says that first part is referring to this explanation 5.3 proviso. It says that person whose name appear in the select list,
Lordship.
that is one. Next para is second proviso. It says persons who have attained the age of 54 years,
Lordship.
if he is eligible for consideration for 1st of January in the year,
Lordship.
but could not be considered. 5.3a, it says the committee shall not consider the case of members who have been included in the earlier select list. Now, why this has been excluded? This is the rules, service rules. So here it says that
Lordship, 5.3a,
5.3a, the committee shall not consider the case of members
yes, yes,
who have been
Lordship, had expressed his unwillingness.
oh, acha. Okay. Okay. Because why negative, I did not understand. That's why I asked you that only question. Yes, now please proceed.
My lord, before my learned friend starts, my lord, I just inform the court, my lord. I represent the respondent number 1, 2, 3, and 4. All of them have retired, and the respondent number 4 has also expired. Just for information.
Okay. Yes.
May I take your lordship to page 51 of the writ petition. The discussion of the learned tribunal. I'd just like to read it, Worship, from paragraph 28.
Yes.
At the outset, it is to be decided whether the select list of 2008 can be treated as select list of 2007, coinciding with the year of vacancies of 2007. In the case of Praveen Kumar, it has been held that a select list has to be prepared separately for each year during which the committee could not meet as on 31st December of each year. Therefore, the vacancies for the year have to be determined as on 31st December of that year. Regulation 211 of the IAS Appointment by Promotion Regulation 1955 defines the word year. As per the said regulation, the year means the period commencing from the first day of January and ending on the 31st day of December of the same year. Indisputably, the applicants were considered against the vacancies for the year 2007. This fact was confirmed by so and so. As such an error has crept in making the select list, we therefore direct the respondents to treat the select list of 2008 as the select list of 2007. Now,
We'll take a break and come back.
Flush. The main dispute in the case is in regard to the assignment of the year of allotment. According to the respondents, the year of allotment is 2000. The applicants claim that it ought to be 1998. It would be pertinent to examine the rules apropos the assignment of the year of allotment as laid down in the Indian Administrative Service Regulation of Seniority Rules 1987. Rule 3 of the said rule speaks about the assignment of the year of allotment. Rule 332. This is important, Lordship. 2. Rule 332. Lordship will note. The year of allotment of a promoting officer shall be determined with reference to the year for which the meeting of the committee to make selection to prepare the select list on the basis of which he was appointed to the service was held, and with regard to the continuous service rendered by him in the state civil service, not below the rank of deputy collector or equivalent, up to the 31st day of December of the year immediately before the year for which meeting of the committee to make selection was held, to prepare the select list on the basis of which he was appointed to the service in the following manner. Lordship, this I'll come later on, Lordship. If your Lordship will come to paragraph 30. From a perusal of the aforesaid rule, it is abundantly clear that the year of allotment of the promoting officer shall determine with reference to the year for which the meeting of the committee to make selection to prepare the select list on the basis of which he was appointed to the service was held. In this context, it may be noted that the year signifies the year of the select list. It cannot be construed to mean the year in which the committee was held. Now, Lordship,
There's three possibilities.
Lordship.
Number one, the meeting ought to have been held in the year 2022. 21, we'll say. 21, it did not take place. It took place in 23. And the select list was prepared in the year, 22 and select list is prepared in 23. So according to you, what will be the date? 23.
Lordship, so far as the,
Meeting ought to have been held in 21,
yes,
did
Lordship,
not take place.
yes,
22 it took place.
Lordship,
Select list was out in 23.
Lordship.
Now, which is the cutoff here according to you?
Lordship, a reading of the rule 2. It will be the date of the meeting when it is held.
Okay,
Rule
it should be date of meeting, rule 2.
Rule 2. The sub rule 2,
332.
332. My submission would be that. And so far as Lordship, the for which year's vacancy, it would be the select list of which year. That Lordship, in the case of Praveen Kumar, Lordship, it has been held by the High Court of Punjab and Haryana. That it would pertain to the whole of the year from 1st of January to the 31st of December, whatever vacancies in that particular year. So that will have to be taken as the year. And the DOPT had gone up against the judgment of the Punjab and Haryana High Court. It was affirmed by the Supreme Court. And therefore, Lordship, it was decided that, Lordship, I take your Lordship to page 60.
No, you make your own way of
Yes.
submission, but I'm just
Because-
asking you this.
It's already there on record. Therefore,
Acha.
I'm placing it, Lordship. That's a memorandum that starts at page 58. And I will take your Lordship to page 60, paragraph 4. In view of the above, paragraph 3 states about the SLP that the ministry had preferred. It was dismissed. In view of the above, the order of the High Court has become absolute. Accordingly, the following decisions have been taken by the competent authority. The said order will be implemented with effect from 1st February. That is the date of the High Court order. Wherever meetings of the selection committee in respect of any All India service has not been held, or meetings have been held but minutes of the meetings have not been approved by the commission, the same will be held in accordance with the interpretation of regulation given by the High Court and by the Supreme Court. Where the meetings have already been held and minutes have been approved, and the same will not be open unless there is a specific direction from a court of law. In the instant case, Lordship, this is a consideration prior to 2010. Therefore, Lordship, the law as it was prior to 2010, prior to coming of into effect of the decision of the Punjab and Haryana High Court, my submission would be that would prevail, Lordship. Because it gives effect from 1 to 2010. And it is very specific, Lordship, that those which have been in 4.2, wherever meetings of the selection committee in respect of all or any All India service have not been held, or meetings have been held, but minutes of the meetings have not been approved by the commission, the same will be held in accordance with the interpretation of the regulations given by the Honorable High Court. Now, once the consideration is over, Lordship, this will not come into effect. And here is a case where the consideration was already over. And ultimately, Lordship, after discussing the Rule 3 and the judgment laid down in Praveen Kumar, the Honorable Tribunal in paragraph 31, I'll just read out. The next issue relates to weightage.
Page 53.
Page 53, Lordship. The next issue relates to weightage. which is to be given to the applicants for determining the year of allotment. It is stipulated in the rules that the service of the officer will be reckoned with regard to the continuous service rendered in the state civil service not below the rank of deputy collector or equivalent up to 31st December. There is no dispute of that. Of the year immediately before the year for which the meeting of the committee to make selection was held, to prepare the select list on the basis of which he was appointed to the service. The matter of reckoning the weightage is also prescribed in the rule. For the service rendered up to 21 years, applicants will get weightage of 1 year for every completed 3 years of service up to 31st December of the year. Beyond 21 years, applicants will get weightage of 1 year for every completed 2 years of service. For the purpose of calculation of the weightage, the fractions, if any, are to be ignored as per the explanation incorporated in Rule 332 of the IS Regulation of Seniority Rules. However, an exception is carved out in this rule in the form of proviso, wherein it is stipulated that an officer will not get year of allotment earlier than the year of allotment assigned to his senior. We have noted that the IAS Regulation of Seniority Amendment Rules 2012. After this, Lordship, there was an amendment. I'll take your Lordship to the amendment after I read this. Issued by notification dated 18/4/2012 are not applicable to the present case, present applicants, in as much as the applicants are not covered under these amendments, in view of the fact that the amendment did not have any retrospective effect and came into force on the date of publication in the official gazette. Lordship, no quarrel on that. As per explanation 2 of the ACS Class 1 Amendment Rules, the year of recruitment of the members of the junior grade shall be taken as 1 year for the purpose of calculating the period of 7 years. As such, whatever the fraction in the initial year, that will be treated as the period of 1 year. The applicants were recruited in the year 1983, that is 1/6/1983, and as such, year 1983 is to be treated as one completed year. No dispute on that. As one complete year, and considering the select list of 2008 as the select list of 2007, it can be said that the applicants rendered 25 years of service till 31/12/2007, holding the rank of deputy commissioner or equivalent. Therefore, as per the procedure prescribed in Rule 32A and B, and of Rule 3 of the IS Regulation of Seniority Rules, weightage shall be given to the applicants for 7 + 2 years, 9 years. Consequently, year of allotment will be year 2007 to 2009. That is 1998. But the seniority will be determined subject to prescription laid down under provision to sub Rule 3(2) or so and so. It will be necessary to see which year of allotment is assigned to the officer immediately senior to the applicants. The applicants will not get the year of allotment earlier than the year of allotment assigned to their senior. Now, Lordship, just sometime back, my learned friend, I got to know from him that in one case it was allotted 98. Nilofer.
Yeah, Nilüfer.
Initially 99, subsequently 98.
So there, Lordship, some I do not have the instructions on that. He has taken it out from the nets. Now, my submission before your Lordship would be, in case we are to calculate the year of allotment and the select list of the orders passed by the learned tribunal, what would be the effect? The effect would be there will have to be a review of the other officers also. Because in one particular year, there are a certain number of vacancies. It might overlap. It might overlap. And here is a case. If we have to review the whole lot, Lordship. That is a big administrative task before us. And secondly, Lordship, so far as Praveen Kumar is concerned, Lordship, much stress has been laid before the tribunal on the case of Praveen Kumar. Praveen Kumar is a case which came later on, after our cases were considered. Had the applicants approached the tribunal, it might have been something different. Here is a case, their cases were considered before. Later on, Praveen Kumar came in. Praveen Kumar said, all right, Praveen Kumar was only with respect to the year of consideration. It was not with regard to the year of allotment. Therefore, Praveen Kumar is restricted only to 1st January of a year to 31st December of that year. And in fact, the state had considered before the learned tribunal that the year ought to have been 2007 instead of 2008. But so far as the year of allotment is concerned, Lordship, my reading of the rule, Lordship, I do not make out any other interpretation. If I read it again and again, it, Lordship, says it's the year when the meeting was held. Though there was a change in the law, so far as the particular year of consideration is concerned, there was no change in the law so far as these rules are concerned. Here, Lordship, again, if I may, because these rules were, Lordship, amended in 2012. But 2012 was a subsequent date for them. Naturally, it would not be applicable for them. 322, Lordship, 3 may I read once again, Lordship? I have not been able to make out a different meaning. The year of allotment of an officer appointed to the service after commencement of these rules shall be as follows. The year of allotment of a direct recruit shall be the year following the year in which the competitive examination, this is the direct recruit we are not concerned, will come to 2. The year of allotment of a promotee officer shall be determined with reference to the year for which the meeting of the committee to make selection to prepare the select list on the basis of which he was appointed to the service was held. And with regard to the continuous service rendered by him in the state civil service, not below the rank of deputy collector or equivalent up to 31st day of December of the year, immediately before the year for which the meeting of the committee to make selection was held, to prepare the select list on the basis of which he was appointed to the service in the following manner. So how the previous years have to be calculated. So that is precisely the Lordship decision which your Lordship has to render. It's only on the interpretation of what would be. Otherwise, Lordship, had it been continued, this the procedure which was being followed, there would have been a lot many cases after this also. But I do not find any other cases. It's only restricted to these respondents, and they have already retired. And if 1998 is to be given, then the cases of 99, 2000 are also to be reviewed.
No, for that, nobody has approached you that to give effect of this order, should be continued to them also. Nobody has approached you for that.
It will open the gates, Lordship.
No, but if you see, but if that is the law, that a particular year of allotment must be considered, the year of meeting must be considered. But then it has to be given effect to.
On that, Lordship, I do humbly agree with your Lordship, but it will cause a lot of. And Lordship.
No,
will-
because if anybody would have challenged it by now, if anybody was aggrieved, they would have challenged it by now.
That is what I was wondering, Lordship. Nobody has come. Lordship.
Nobody has come. Nobody says that this exercise should not be done.
Nobody has come. Lordship. That was, and in the meantime, Lordship, somebody's.
No, they'll get notional benefit. If
I was just wondering whether it carries any financial benefit. If it does not carry any financial benefit, then this is a closed chapter. But I am told it does carry a big.
it will
financial
definitely carry, if he becomes a year senior, then this calculations has to be made.
But they have been given 99 as of now,
Yes, Mrs.
Which-
Chaudhary.
which
My lord, there will be financial benefits. There will be financial implication of this.
There will be financial benefit.
Now, if my learned friend has completed, my lord,
Huh?
Personally, my lord, this, if we see technically, my lord, this reputation is defective. In as much as if your lordship comes to the impugned judgment at page 37, large number of OAs were decided by the judgment. I think 24 or 25. 25 cases were disposed of.
Yes. 4-5 cases are there.
No,
One case,
1, 2, 3, 4, 5,
Four,
6,
five
7,
cases.
8, 9 and 10. 10 cases.
10 cases, but 25 or more persons, my lord.
Okay.
Now, this writ petition has been filed challenging this order, but making the, my lord, applicants in the other ways as respondents. Am I clear, your lordship?
No,
If your lordship sees the parties that have been made
yes.
in our way, my lord, in our way, we are 4 petitioners, 4 applicants.
Your OA is 040,
124 of 2012.
124.
That your lordship finds at page 37, we are 4 applicants there.
040 is a state court, Lordship.
One 124 are 4 persons.
Yes, my lord.
Ah.
Now your lordship will see the name of the parties of the respondents in this writ petition.
Hmm.
There are, my lord, as many as 25 petitioners,
Yes.
respondents. So these other respondents, other than these 4, are applicants in other cases. So they, in their cases, my lord, no challenge has been made. Only, my lord, they have been made parties in this petition, and perhaps that is the reason why, my lord, they did not appear. None, my lord, except these 4 petitioners that I represent, my lord, they have appeared. That is a, my lord, technical flaw. Either, my lord, they had to file separate writ petitions in respect of all the OAs, or they could file only one writ petition challenging this order where we are parties only 4. That is only a technical part, my lord. That's
No, you come to page 2 of the writ petition. In the matter of, he has passed the, referring to the common judgment.
yes, my lord.
Now, now page 22,
Yes.
again, the challenge is to the common judgment in referring to all the cases.
Yes, ma'am. Normally, when we, my lord, challenge one order, my lord, in one case, for instance, my lord, in the writ appeals, if there are, my lord, 3-4 judgments, different parties, my lord, then we have to file separate writ appeals. So they ought to have filed a separate writ petitions. Challenging each, the same judgment in each of the, my lord, cases. Anyway, my lord, I'll not, my lord, this technicality much, my lord, the submission, as I have understood of my learned friend is, my lord, primarily the interpretation of the rule. And my lord, that the Praveen Kumar's case is subsequent, therefore it cannot have retrospective effect. Firstly, my lord, if your lordship reads.
Just a moment, just a moment.
Remember the ideas. Correct. Take this as a gift. Like I said, I'm so sure I'm so retired with it.
There is a preliminary issue on the maintainability note.
my lord. No, in fact, my lord, I was just pointing, I am not pressing on that, my lord.
Okay.
Now, my lord, the main issue here is the interpretation of that particular learned friend was, my lord, pressing. May I read that once again, my lord? Rule 3 of the Indian Administrative Service Regulation of Seniority Rules. Rule 3, I'll read, my lord, Rule 3.3, Sub-Rule 2. Again, my lord. The year of allotment of a promoting officer shall be determined with reference to the year for which, these words are important, my lord. Year for which the meeting of the committee to make selection, to prepare, etc., etc. Not, my lord, in which. Had it been in which, perhaps, my lord, his submission would have carried meaning. For which, means, my lord, for the particular year. So, my lord, the proposals were sent in 2007 and 2008. And the vacancies were of 2007. Therefore, my lord, for which will mean 2007, irrespective of, my lord, whatever, my lord, later years the selection has been held. For which, my lord, for the year 2007. Now, my lord, this has been fortified by their own, my lord, notification. If your lordship kindly comes to,
You see, let us say
my lord,
that example I have given
my lord.
earlier. Now,
Let us say that in the year, because of that, say for COVID and all everything, 19 and 20, the meeting did not take place.
Yes, my lord.
The meeting took place in the year 21. So your interpretation would be for the year would include 3 years.
No, my lord. For the year will include, my lord, each year separately. For the, my lord, your lordship said 2019, 20 and 21.
21.
So for 2019, there has to be a separate selection for that year. Then, my lord, 2020, a separate, my lord, selection. Because, my lord, proposal is sent for each year separately. Therefore, irrespective of the fact that it has been held in 2021, the year for which the selection is made is 2019. A mere reading of this, my lord, sub-rule 3 will make it clear, my lord, for which, not in which. Now, my lord, as I said, the fortification of this principle by the my lord, Department of Ministry of Personnel. What happened, my lord? After the Praveen Kumar's judgment, there has been an OM that your lordship will find at page 58. In that, my lord, OM, the government has, my lord, discussed the principles that have been laid down by Praveen Kumar. And I'll take your lordship to page 59, line about, my lord, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 9. Line about 9, my lord. The line starts with on January 1. The sentence starts with in the present case, as your lordship got it, my lord. In the present case, 4 vacancies are of 2006 and 1 vacancy of earlier years became available in the year 2006 on account of non-joining of Sri Joginder Lal Jain. It has been rightly condemned that the emphasis in regulation 5.3 is on the expression the year for which the select list is prepared. Now, while agreeing to this, my lord, it's not that, my lord, the Praveen Kumar has laid down a fresh law. Praveen Kumar has only interpreted, my lord, this particular clause and said that it will be for the year for which the selection is prepared. But my lord, if your lordship comes to page 60, they want to fix a cutoff date for implementing this. Page 60, your lordship will find, in view of the above, the order of the Honorable High Court has become absolute. Accordingly, the following decisions have been taken by the competent authority. Clause 1, the said order would be implemented with effect from 1st February 2010. That is the date of the High Court's order. That means, my lord, prior to it, that particular clause cannot be implemented. That is not the law, my lord. That is not the law laid down by the my lord Praveen Kumar. Praveen Kumar has only, my lord, explained that the year of allotment will be for the year for which this election is made. That is already in the statute book. Only, my lord, it has been clarified by Praveen Kumar. Therefore, my lord, this cutoff, the fixing a cutoff date is, my lord, of no consequence.
How does this 2010 materially affect you?
My lord, 2010, because, my lord, our selections were held in 2009. Our selections were held in 2009.
2009.
Fine.
Oh.
Although vacancies of 2008,
You ask a question. Ask a question. No problem.
This OM,
my lord,
it's issued after the Praveen Kumar,
yes,
and they said it's implemented from with effect from 1st
first of
February
February
2010. Are you agree with this?
No, my submission is this, my lord. This explanation OM does not, my lord, change the law. They cannot put a fetter on the, my lord, law which is already there in the
No,
statute book.
that is correct. But one thing, if you are agreed to what they have decided, the central government,
Fine.
by issuing this OM, which is still
No,
standing.
my lord, if your lordship kindly comes, I'll place some orders because I thought that may not be necessary. I don't put out.
No, we're just asking whether if you suppose they say the order would be implemented so and so, so and so.
Right.
If you are agreed, have you challenges or
No, I
Are you
need
not
not challenge also.
agreed to it?
I need not challenge it. Challenge also, my lord. On this ground, my lord, our request has.
So
not-
you have no problem.
I don't have any problem. In fact, my lord, law does not have any problem with this. Now, my lord,
But once we accept this OM,
my lord,
which is still still,
my lord, it does not specifically say that earlier selections will not be as per the Praveen Kumar judgment or as per the sub-rule 3, which has been explained by Praveen Kumar. It doesn't
after
say.
acceptance of the Praveen Kumar only, this OM has been issued,
Yes, my lord.
wrongly or rightly.
Yes, my lord.
And nobody has challenged this as on today.
There is no requirement so far as we are concerned, my lord. There is no requirement because, my lord, the rule sub-rule 3 is, my lord, very clear. Only, my lord, there has been, my lord, read by the Praveen Kumar judgment, which has been, my lord, upheld.
It's okay.
The court cannot, my lord, the authorities cannot put a cutoff date for this.
No, you
it's
see,
not
that is what my brother is asking.
my lord.
Once in the OM, a cutoff date has come, and that is not challenged. Then whatever be the interpretation, it will ultimately this OM. They will follow the principle laid down in the OM because there can't be a judicial interpretation when it is not under challenge. We may say anything with regard to Rule 332.
that has been, my lord, explained by the.
But to implement or not to implement that OM, that will not be a part of the order.
Yes, my lord. It should not be, my lord. In fact, my lord, I place on record what happened, my lord, after the the OA was disposed of. My lord, 2 orders have been passed. May I place it on record, my lord? जैसे दूसरा को भी ऐसा नहीं दिया ऐसा हमने दिया तुम्हारे को दिया दूसरा कर दिया ऐसे let us see, my lord, what is the stand of the Ministry of Personnel after the judgment was passed. This is, my lord, communication dated June 27, 2013. May I read it, my lord? With reference to the state government of Assam's letter number successors dated 13 July 2012 and letter number successors pursuant to the Honorable CAT Guwahati Bench's order dated 9 November 2012. My lord, my lord, pause it for a while. Our OA was filed because, my lord, the dates may be relevant because the question, since my lord, question of cutoff date has come. Hmm? 15, na?
Because this OAs are of 2012,
Yes, man.
after this OM
After 2000.
of 2010.
Yes. Yes, madam. Now, madam, this is the decision of this of the matter authorities. Writ petition in Guwahati High Court as advised by the DO, that is the advice. Then it was pointed out, your Lordship may skip, my lord. In view of the above decision taken pursuant to the aforesaid direction of the CAT, the seniority year of allotment of the applicants in OA, namely Muhammad Sorab Ali, that is our petitioners, has been computed under Rule 332 of the IS regulation, seniority, and my lord, we have been already given allotment of 1999. Your Lordship will find in the chart the first, second, third, fourth, fifth, sixth column, year of allotment. Now, your Lordship may skip and read paragraph 4. Paragraph 4, as per Rule 4 of the IS Regulation of Seniority Rules 1987, 6 officers who have been appointed to IAS on the basis of the state list of 2008, namely Shankar Prasad Nandi and Srimati Ritika Das Kalita, Muhammad Sorab Ali, the petitioner number, the respondent number 1, Pritam Soikia, Dilip Borthakur, other respondents, Anupam Kumar Roy, shall be placed at Seriatim en bloc below Sri Nilufar Alam Hazarika, IAS, the junior most promotee IAS officer of 1999 batch, and above Sri K.L. Tariang, on the only promotee IAS officer of 1999 batch. So, my lord, since we will be getting after Nilufar Alam Hazarika, we have been placed in 1999. Now, my lord, what happened thereafter? Because this was also not correct. Because Nilufar Alam Hazarika was wrongly placed in 1999, and subsequently we have downloaded from the my lord web. Your Lordship will find 139 or Nilufar Alam Hazarika has been allotted 1998.
Because you see, why we are asking that question is for a different reason. Number one, it's a well settled law that insofar as the legislature is concerned, they have a power to pass a law with retrospective effect. And the law laid down in many authorities is to the effect that there cannot be a law to restrain the effectiveness of the order of a court. If there is an order of the court, that cannot be retrospectively negated by virtue of a legislation. But in this OM, when the restrictive clauses come, definitely that has to be challenged to say that the judgment in Praveen Kumar could not have been negated by this OM, because in effect, the operation of that judgment is being negated, or it has been restrained from a particular date. So if there is no challenge to it, then that status remains.
My lord, my submission will be, we have approached the tribunal by showing that there are errors in in preparation of the list of 2007, 2008, 2009, and that it should be corrected. And the tribunal has, my lord, given the my lord judgment, holding that will be entitled to 2000 to be considered for 2008 batch year of allotment. So that has already been held, my lord. Now, on the ground of existence of such an OM, my lord, this judgment cannot be set aside. And that is, I don't think, my lord, that is a ground taken in the writ petition. In the ground, my lord, although my learned friend had given an indication, but then, my lord, that is not the ground on which they are challenging it. And in the pleadings also, my lord, perhaps in the before the learned tribunal, that was not the ground. Because in the judgment, my lord, nothing has been stated about that. About the retrospectivity or otherwise.
Because in para 19, there's a ground said. Page 19. We mentioned that while considering the proposed amendment in the rules, in this department, the issue whether it will be legally defendable to make amendments, especially since shall be prepared as per so and so. Question is whether the proposed amendments can be made operational with respect to the issue has been considered.
My lord, in this ground, they have only stated that this has been considered and such a decision has been taken. But my lord, I do not find anything which says that because of this, the impugned judgment is bad. And we need to, my lord, go through the pleadings before the tribunal, as raised by the, my lord, the Union of India. Because, my lord, initially the OA was allowed. Against that, writ petition was filed, saying that we didn't get an opportunity of filing our response. Then, my lord, the earlier judgment was set aside. And, my lord, they were given the time to file written statement. And after this written statement, my lord, this petition was, the OA was disposed of.
You are showing us this for what purpose?
My lord, now I'm showing this, Srimati Nilufar Alam Hazarika, who was given 99 year of allotment, and that's why we were also given 99. Now she has been, my lord, allotted 1998 by the central government at my lord, serial number 139.
Yes.
Therefore, we also come immediately after her. So it is 1998, not 1999.
Her year of allotment was altered
Yes, my
from
lord.
99 to 98.
Yes. And we were given 99 because Nilufar was the immediate senior, and therefore we could not be given 98. We were given 99. That is the order, my lord, that the earlier order I have placed. Subsequently, she has been given 98 by the central government. So we come in 1990.
That position I am not aware. I have to take instructions on that because he has
But here,
downloaded it from.
here your name is shown 2000, not 99.
No, this,
In this list.
this,
No.
that I do not have. That is the initial.
Yes, that was originally, my lord, before the OA was there.
98. Here, it changed in 99.
ऐसा that will go fine, my lord. That will go fine, my lord. Enough goes in it.
But then this has to be put on record. Because here she is saying this is 99, was transferred to 98. Then this will go from 99 to upwards. Sort of is this one.
Your lordship's query is right, my lord. Why we are showing 2000? In the meantime, we have not been allowed.
No, but my brother appears to be right. You see, this 27 June 2013 you are showing us.
Yes.
Now here, Nilufar is your senior.
Yes.
She was given the year of allotment of 99.
Yes,
this-
by that order, earlier.
by this,
Yes.
Now you are saying that she has been given a allotment of 98. But then also, if you can't be given that, you will be still in 99.
No, my lord, by this, the earlier order, this order, we were given 99 because Nilefar was given 99. If your lordship reads clause 4 again, my lord, clause 4 of this notification dated June 27, 2013. As per rule 4 of
Which
the.
page?
My lord,
Which page?
uh,
Oh,
clause
this rule.
Yes.
This one.
yes, yes.
Okay.
Para 4 in the second page. As per rule 4 of the IRS regulation of seniority rules 1987, 6 officers who have been appointed to IR on the basis of state list of 2008, namely Shankar Prasad Nandi, Ritika Das, Saurabh Ali, Pritam Saikia, Dilip Bhattakur, Anupam Kumar Roy, shall be placed at Syria team N block below Nilufar Alam Hazarika, the junior most promotee IS officer of 1998 batch.
Nineteen ninety-nine batch.
1999 batch. Now she has been given 98. We were given 99 because our senior was in 99. Now senior has become 98. So that's it, we will go to 98. Instruction will only go one.
No, but your rule says, the rule which you have read, it says that you will not be given the year of allotment of the senior.
No, for the year of vacancy, my lord. The year of the rule, no, we cannot supersede the senior. We cannot supersede.
No,
naturally.
that. We come to this 3-3.
Yes.
Quoted in that judgment.
The year of allotment of a promoting officer shall be determined with reference to the year for which the meeting of the committee to make selection.
Then page 53, provided that he shall not be assigned a year of allotment earlier than the
Year of
year
allotment
of
assigned to
so-and-so.
an officer senior to him. It cannot be earlier. But it can be the same year.
It can be same year.
Yes. Year of allotment assigned to an officer senior to him in that select list or appointed to the service on the basis of an earlier select list.
So you can be placed en bloc junior to her.
Yes.
Okay,
I-
you continue to.
That, Worship, I am not privy to that.
In fact, my lord, we had given these copies to him
No,
today
no.
only.
I have received this.
No, but you'll have to take
I am privy to that.
instructions.
can I take
No,
instructions?
we'll have to give you time.
Yes, because I have not seen that. And I
No,
don't
we'll
know
have to give you time if this is a new document.
This is downloaded from the
Website.
official website. There may be mistake also, which you are relying, this one or this one.
Both.
This, it's given 1999.
Yes.
Year of allotment to
Yes.
your senior.
Yes,
According to you, from which year your allotment should be?
98.
98, because senior is promoted to 98. They were placed en bloc below her. So they also go to 98. That's what this.
So we are relying on both these documents.
I don't, we don't think so. You cannot rely on
No,
either of the two.
no, both right. Because this
Initially, it appears to be correct.
that is correct to the extent that Niloufar was in
99.
90
99.
yes, 99.
So by
Now,
this,
Niloufar has
when
subsequently-
she has been allotted 98,
Yes,
you goes automatic.
we also get the same benefit.
Same year of allotment.
Yes,
But you said she is senior to you,
yes.
which proviso says that you cannot.
No,
Where-
proviso says that we cannot be given above
Above
our
her.
senior, but we can be given the same year of allotment.
You have to file an affidavit, bring it on record.
Yes, my lord, I'll bring out on record against. I thought that these questions may not come up. That's why we did not. We will put it by an affidavit on record.
No, because we'll have to touch upon it and then
Yes,
say,
yes.
because 2010,
Yes.
OM is there.
Yes,
You are claiming benefit from that judgment, saying that irrespective of that OM of 2010, 2012 judgment gave you that benefit.
yes.
So therefore, you are now saying that you are not required
That
to.
particular document before the my lord tribunal, we didn't know. We are not privy to that document. In the written statement, they ought to have taken this ground. That the government has decided to act upon it prospectively. Then, my lord, we could have made a challenge. This document has been annexed for the
is,
first time, my lord, in the writ petition. And in the meantime, our writ petition was.
It's okay, you bring it on record because then I think things will.
That will be easier for me to get a clarification.
Huh.
And that retrospective lordship, perhaps I would not agree 100% with my senior. This notification came later on. And the effect was given from the date of the judgment. Date of the judgment was 2010.
No, that means you see, even though challenge is not made, but then you are.
There is some restriction
No, but then you are discriminating from on the basis of a year. But that goes against to the root of Article 14,
That I will explain, Lordship. That I will explain.
because there has to be some intelligent,
Differential.
what do you call it? Differentiate.
Differential.
Questions, my lord, interesting questions have come up.
It is good, I am learning something from the senior. lordship.
No, for us it is not good because it's 2016 matter. We are
Lordship will
planning
not
for,
give much time. Lordship will not give much time, but.
no, we don't know tomorrow. Who knows about tomorrow? Huh? We are not seeing tomorrow. Tomorrow we may not retain the memory which we have, of what we have discussed today.
No, Lordship has got a sharp memory.
No, definitely not.
We should be able to file within a week, my lord. Maximum within a week, we'll file the affidavit. And my learned friend will take some time for obtaining instruction.
No, do it because this is a default bench. It's not a usual bench. Mr. RKD Chaudhary done it. DHGI. Yeah, appearing for the appellant.
Petitioner, Lordship.
Petition, petitioner, my lord.
Oh, sorry, petitioner. For the petitioner. Mr. M.K. Chaudhary, done it, senior counsel. Assisted by Mr. M. Khan, counsel for responding numbers 1 to 4.
1 to 4, but 4 has expired in the meantime.
Acha, 1 to 3. Praiseforeign is granted time to file an affidavit to bring on record additional document on which he intends to rely on. Next paragraph. The, upon instructions, the learned senior counsel for the respondent numbers 1, 2, and 3 had submitted that he was earlier appearing for respondent number 4, but as per his instructions, respondent 4 is expired. The said statement is noted.
Substitution
List
will
on
play actually.
when
Substitution.
list after 2 weeks.
After 2 weeks. Can I pray for a fixed date, my lord?
No, because you are filing an affidavit.
Yes.
You can always. By the time we understood, we are adjourning.
I'm sorry to say that, my lord, judicial time has been a little wasted, my lord, by us.
No, for my brother is more acquainted with service matters, so he is fast in catching, and I'll be.
In
So
fact,
his lordship has put a very
No,
pertinent question, but I was.
it took me little time to understand.
no, Lordship, it took me more than a week because this petition have not been satisfied.
No, your lordship's question was very pertinent. and-
Otherwise, you don't have case at all. You don't have ground. Otherwise,
But for that. Something on personal note.
boundary of the house to the house and that of my husband, mother, and sister has. Only to elect the post on this room. Following that, the post number 1, father, step my husband, who is our sharp weapon like spine used for fishing. As a result, my husband sustained various injuries on his head. Saying this, my husband being stabbed. When my brother-in-law accident has taken place, the accused number 1, accused number 2, Gabriel Jawad, and accused number 3, and then both of them, both the accused have been 3 point various injury to prosecuted 2 by stabbing him with the Jawad. Immediately, both the injured persons were taken to same seats by the ambulance. And the doctor declared my brother-in-law hospital had died. He witnesses to the person. At the prosecution side, examined as many as whatever cases. The case number 1, Nilima Das, who lost the affair, has acted is at place 9.
Page
Place 9.
9. Yes.
Said as is known to me, being my neighbor. Besides the western boundary of my house, I have the involvement of this case. On 15 May 2013, at about 9 a.m., Vanessa and confidence was started digging art for erecting this room on our boundary. On seeing this, I have intimated the matter to my husband, Sri Madan Das, who came to the same place of digging art and restrained the accused Manisha Das punishment for in digging the art in our land. The accused person did not pay the objection and ended the quarrel with my husband. During quarrel, Manisha asked his wife Monica to bring a single spike pointed spear whose bamboo handle, which they brought which he brought and handed over to the Manisha. After taking the same single spike pointed spear, the accused Manisha stabbed the same with the head of my husband and caused grievous injuries on his head. Blood come out from the same injury. All my time as brother-in-law, the husband younger than that, Masuddin Das, last to the face and arriving there. Accused Manasa has stabbed the single spike from the spear on the chest of Masuddin Das. On getting it, stab injury and simply the Masuddin Das killed them there. Purpose by the iron country of the obstructed the Masuddin on the island. On raising hue and cry, the neighboring people gathered there and only by them a single pointed square began to happen. Broken and whenever in place of violence, it is guided. During the above occurrence, I was standing in the place of occurrence near my injured husband. The villager council on the right ambulance and police station of the court. Within 15 minutes, the occurrence is very sad. One right ambulance. My husband, the accident was brought to this in My husband was treated at James's hospital that was the camp for targeted by Dr. After taking treatment, my husband began and continued for 5-6 days and the daily attendance and treats. I loved that within I think it's medical incident. Exhibit one is my exhibit one is during this incident, the single spike pointed spear of the temple and then I can recognize the same weapon from the pyramid. Material exhibit one is the same single spike pointed spear of the temple and then used. Assaulting my husband and possible. I have this description of the police as state figure. And the consequence was the land on the dispute between my husband and the accused officer is very since 10-12 years. In between the two boundaries, the accused persons is no boundary fencing. We showed the boundary fencing. Some trees, some trees, there is nothing within the houses. I cannot be land of the boundary of the north to south. In family, in our family, about 10 members are there, including children. Myself, family consists of my member. Vasudev was available and the children. Please present and these parents and the state. On the date of occurrence, the homicide has digged a hole for erecting the Patha house. The land was digged by homicide and purple. That's only. The labor was not there. the whole thing might be 1 cubic by 1 cubic inside. When calculus was mentioned mentioned by the indeed, it is not a fact during the quarter and the western of the coastal within the whole. A Vasudev brought this single spec content square with the Rambo and from our land and handed over to the husband and instigated him to state the accused. It is also a fact, it is also not a fact that my husband attempted to state the accused. Manesar and is Manesar restricted husband and during this couple, a single spec content square with the Rambo and with the Vasudev. It is not a fact that my husband lots of the private visit on the public arts. I lost it and read about the I'm going to Hazard Deals. FIR was written by one club. Before filing the FIR, I got information by Vasudev. That's was that by James. On 11, the police reports of occurrence, last things were available below, and it cannot say over the Genji and Ramsa, from the different time and the project with the deputy after at the time of the quarrel which man was paid in country which are used in the Hindi art and for the act of the place of friends. It is not a fact that while giving the statement to the police or the affair, I have not stated giving statement living by national arts is right and the fact is giving respect and spare whom the more and let's see about the language. It is not a fact that the statement made to the police or the affair I stated during quarrel of the nurse was their component by the iron country which for the abstracted conspiracy on the it is not a fact that that's was the iron country abstracting the conspiracy on it is not a fact that the single strike on its death is the wrong way. It is not a fact that the injury is like let's see the
Mr. Sharma, just to understand the entire matter.
Yes.
Number one, PW1 is an eyewitness who saw that assault. PW2 is the victim who also states that because he is a victim, he saw the assault. That is Madan Das. Now, PW4 and 5 are also eyewitnesses.
eyewitness they came when there was event trial.
They came, but they saw it, that the stab injuries were there and you were there. That is placed. Now, PW6 is the doctor. He did the postmortem and the nature of injury, he says, with a sharp pointed weapon. So that is matching with the inquest report where the injury is given. Then hearsay witnesses are PW4, 7, 9, 10, 11, and 12. They are hearsay witnesses. PW3 is the OC who gave it to the IO to conduct the investigation. Now you see the incriminating part comes in your statement made in section 313 statement. There is the last query. You have admitted that there was a fight. He said it is your version that he brought the ekhalia.
Yes.
And then there was push and pull, and then somehow he got hit. So therefore, you see the not only everything else falls in place, but your statement in 313, and there you said that you will give evidence, but it was not given. Therefore, that what you call the chain is complete insofar as prima facie reading, because I have not read the entire thing. I just, what do you call, an overall reading. I have not intrinsically gone into it, but this is what the impression I am getting.
But the PW two also, he also stated, my lord, the cross examination. The whole thing is this, my lord, the police has prepared a sketch map.
Yes,
In this sketch map, which is the a hole was dig on the side of the accused. And they came and obstructed the digging on the land of the accused. If your lordship kindly PW 13,
sketch map is 109.
sketch map is. A is the hole.
A is the whole.
Yes. And B is the residence of victim. And the C is the residence of accused. So, hole was dig on the side, on the land of the accused.
Because you see, right of private defense, that is a clause which you can invoke, but then there's no evidence to show that they were armed, except for the 313 statement. So because when the presence of equalia is admitted, then I think burden will shift on you to say that how this arms were there, because right of private defense, you could have assaulted him. But then the chain has to be completed insofar as your version is concerned. So there I am finding some difficulty, subject to what you submit.
Well, the evidence of IO PW 13 is page 39. No, 39. Okay, that's not. It is cross. Page 39 is in the cross. It starts from 37. On 15/4/2013, I was working as OC of Hazu PS. At the time of the informant, Nilima has lodged an FIR, lodged an Azhar, which is Exhibit 1 on the basis of thereof, Hazu PS, and was registered under Spencer. Exhibit 1(1) is the signature of the informant, Nilima Das. Exhibit 1(2) is my signature. Exhibit 6 is the printed form of the FIR. 6(1) is my signature of the informant signature. According, therefore, I myself investigated during my inspection the place of occurrence and drew a rough sketch map. At Exhibit 7. Exhibit 7(1) is my signature. At the place of occurrence, I says Akolia, which is Caesaris, Exhibit 4. My lord, here, my lord, the Akolia is a single spike, with bamboo handle.
Using fishing.
Fishing purpose. But in the FIR, it is stated that it is a Zoar. Zoar is a multiple spikes in the bamboo. There are two things. So far, FIR it says that it is a Zoar with a multiple spike. And in the it is stated, the police has stated, it is a Akoya, a single iron
Iron spear.
with bamboo handle. There are two FIR and these things are two different things. The by
But the Caesar is Apollyon.
Akoya. And in the FIR, it is a Jwar. At page 4. Page 4, not 5. Page 5. It starts from page 4. The accused number 1 with an attempt to murder stabbed my husband with Jawar.
Fire. You just see this. So that's. Just
See this, the original FIR, the photocopy of the FIR I'm sending you. In the fifth line. What is it said? Jwar,
এজাহারকারী বীর এই যে আজি 15/4/2013 তাৰিখে ৰাতিপুৱা প্ৰায় 9:30 মান বজাত উক্ত 1 নং পদকীয়াই আমাৰ আৰু পদকীয়াৰ জমিৰ সীমাত পকী ঘৰৰ পোষ্ট পোটাত মোৰ স্বামী মদন চন্দ্ৰ দাসে পদকীয়াক নিজৰ ঠাইত পোষ্ট পোটাৰ কথা কোৱাত উক্ত সন্দৰ্ভক লৈ 1 নং পদকীয়াই হাতত চোকা অস্ত্ৰ মাছ হানা জোৱাৰ এপাত লৈ
so you see, that's why only that much. Mane, that is used for killing fish.
yes
But for the purpose of killing fish, Jwar will not have multiple, what you call, multiple points.
yes.
Because for the purpose of angling, what is required is only one spear. So they may have called it Jwar, but it is not a what you call spiked item, because that will not be used for killing fish.
No, it is used for killing fish.
No.
It is a multiple, so many spikes are there, and they will see the fish and put the spike on the fish.
Fish is normally one.
Fish is normal, but during flood, when the landed fields are flooded with water, then the people are using this jwar. I know. I went to-
Maybe because I may have difficulty in understanding that,
Yeah, I
being a vegetarian. But
know
I was,
I happen to be in the village sometimes. during
no, that is
class.
okay. But you see, the use of words may be there, but the multi-pronged is not there in that FIR.
But Juar is generally we mean it is a multiple spikes. And the Ahia is the one.
Yes.
Page 39, you also kindly see. Witness number 13 is the IO. This cross-examination may kindly be seen. Page 39. I visited the place of occurrence at about 12:20 p.m. The accused appeared at the police station, and the subsequent of his appearance, the informant lodged in FIR. The time of appearance of the accused in the police station is not recorded in my diary. I have not made JD entry for surrender of the accused person in the police station. After surrender of the accused, I made an inquiry of the incident and thereafter the preliminary investigation visiting the place of occurrence. I recorded the statement of the accused person in the police station. I caused examination of the accused person as per law through the medical officer and I collected medical report of the accused where it reflects that he received injury on his waist. In my sketch map exhibit 7, there is no indication that there were houses on the other co-villages except the house of the informant and the accused. It is not a fact that since I have not mentioned the name of any villagers in the sketch map, I have not examined any villagers during my investigation. It is not a fact that I have not examined any of the residents of the place of occurrence during my investigation. As per sketch map, place of occurrence is mentioned as as A is within the compass of the accused Monester Das. The hole which dug by the accused was on the boundary of the touching the boundary between the parties. I have not specifically mentioned in the sketch map where from the weapon of offense was recovered. But I have mentioned that the weapon was recovered from the place of occurrence that is mentioned in A of the sketch map. I recovered the weapon of offense of the place of occurrence. In the FIR, the weapon of offense was recorded as Zawar, a multiple spike offense weapon. And but I recovered a single spike weapon, which is called Akilia. And it also says to the present case. It is not a fact that the weapon recovered by me was not an weapon of offense, and it is a weapon mentioned in the FIR. Exhibit 4, I have not mentioned the weapon recovered was stained with blood. It is not a fact that the material exhibit was not used at the alleged offense, as it is done in contain the blood stain. I have not collected the fingerprint of the accused during the investigation. The weapon of offense was not sent to the forensic examination to prove the fingerprint of any person, including the accused. During the investigation, after recovery of the weapon, I have not seen the SIDA list material exhibit to the court for signature. I have not seized the bloodstained clothes from the informant. I have also not collected from the place of occurrence. I could not collect the sufficient evidence against the accused Kalpadas and Namita Das, and accordingly, charge sheet was not submitted against them. PW1 was has not stated before me that during the quarrel, the Manisha Das asked his wife Namita Das of being the single spike spear of the bamboo handed which she brought to the hand of the over the Manisha Das PW1. However, has not stated before me that one Kalpadas, which one iron conti obstructed the Vasudev on his arrival at the place of occurrence. PW2 has not stated before me the time at the time of occurrence, the Lima Das and the wife of the accused were were present in the place of occurrence. PW2 has not stated before me that accused asked his wife to bring the Akeli, which his wife brought and handed over the same to him. PW2 has not stated before me that one Vasudev was not intervening the accused with the country. PW3 has not stated before me that he saw the accused person placing the weapon of offense on the chest of the deceased Vasudev Das. PW3 has not stated before me that he saw the country in the hand of Kalpadas. PW3 has not stated before me that the witness with the blood oozing injury in the head of the Madan Das. PW3 has not stated before me that he has on the other 3 or 4 villages arrived the place of occurrence. The accused disappeared from the place of occurrence. PW3 has not stated before me the incident took place in the house campus. I have not examined PW4, Jyotish Das, PW5, Dhiren Das, and the examination by another witness, another IO, AK Azad. It is not a fact that I have, before filing FIR, there was an Ejahar lodged by the Manisha Das, which I refused to accept. It is not a fact that such allegation of the occurrence, there was a quarrel between the modern Manisha and Vasudev, and the scuffle, accidentally the weapon called the weapon of fishing has caused the injury to the stomach of the deceased. It is a fact. It is not a fact that I have not properly investigated the case and wrongly submitted this as.
But you come to page 49.
Yes, Madam, that is the 313 statement.
Yes. Here he admits that it was a Opola. Apolia. This is Apolia here. So therefore, the benefit of whether the that weapon of assault was a Jawar or a Apolia, that would not be that would not be making much dent in the case of the prosecution, because let us see this PW1. You please come to that PW1, which is at page 9.
The accused Manisha Das is known to me.
You see in the cross, come to page 11.
The land.
No, the second para. It is not a fact
It
that
is
while
not a
giving
fact.
statement to the police, I have not stated that Mercer asked his wife Namita to bring a single spike pointed spear with bamboo handle, which she brought and handed over to Mercer. So this is a question which is put in cross, and she is giving an explicit answer. Because instead of creating a doubt in the cross-examination, rather a question affirming the assault and the weapon of assault has come. This would be a fatal question to ask in a cross-examination.
As per Caesar list also, my lord, as per Caesar
No,
list. 105.
Mr. Sharma's intention is to create a doubt.
That
That
there are
if the
multiple,
weapon of assault itself is a different weapon. And this injury could not have been caused from that. Therefore, he gets the benefit because it's a principle of what you call strict proof. So if the weapon changes, the nature of injury caused was a single spiked injury. So that would be doubtful. So that is the intention of Mr. Sharma.
no, there are two kinds of, my lord, fish hunting, yeah, my lord, spear
No,
like.
I don't know because you see in a village,
In village, one kind, one
no,
is
what
multiple.
I'm trying to say is that different.
Hmm.
My point of view is that I may make a mistake, being a resident of a town who has hardly seen village. I may make a mistake in saying Jwar as a polia. I may make a mistake, but villagers would not make mistake when it comes to agricultural equipments. They will not say spade, like you see, for example, the Hasi. They will not say it is a dao.
Yes, yes.
They know the difference. But when I say, I may say it to be
Hasi as a dao also.
dao also or kotari or anything.
Yes.
But that mistake will not be made by a villager. That's that's the point I'm trying to make. Agricultural equipments, they will not make a mistake. Because there is a division bench judgment of this court, I often say, because I was present in court watching the proceeding, that's why I know about it. Justice P.G. Agarwal in a division bench with the Honorable Chief Justice, I forgot who was presiding the bench. There an issue arose as to whether the weapon of assault was a dao. And Honorable Justice Agarwal, P.G. Agarwal, he was very convenient in reading the LCR. So he saw the LCR and found that it is a Hasia. And then he could demonstrate that the nature of injury which was caused could not have been caused with that weapon, because according to Justice Agarwal, that normally few days back also I said same thing, because you see when it's a Hasia, then normally it is used for cutting grass. It's not a weapon of assault. And therefore, the nature of injury which was caused could not have been caused by that, and he got an acquittal. So, a dao also has many varieties. A dao may be of different varieties. Like, for example, Arunachali dao, it's a weapon of assault. You can't escape if you are hit by that. Similar nature is that the talwar of Naga communities, they are very, very sharp and very heavy and heavier than Arunachal, I think. Naga dao would be heavier than Arunachali. So Mr. Sharma is on that. He's creating a doubt. If that is not the weapon of assault, then perhaps the rest of the story fails, because then it is not the eyewitnesses are not believable.
As per evidence, my lord, I suppose, my lord, there should not be a doubt. Because categorically it has been said FOLA. FOLA means one-sided.
I understand.
One-sided. Now, my lord, there are two types of, my lord, fish hunting apparatus. One is, my lord, we used to use that jaru like shape. multiple spokes are pointed and fitted in a bamboo stick. That is one kind. And one kind is bamboo stick. They are fitted with one rod with a hook, single rod. Now here the weapon is this single, because Caesar list you will see, kindly see page 105. Because as per evidence, accused threw the weapon of killing and fled. So police had the opportunity to seize it from the place of occurrence itself. So Caesar list 105 says,
Yeah, I'll come to you. Mr. Sharma is not yet complete.
no, I only that point. He will argue. 6 feet 11 inches long, including the handle, iron gaff with a bamboo handle. The forepart is sharp and there is a hook on it. One hook, that means the iron part is one spoke, one rod.
No, you see, because this is there is another aspect to it. No one, this was not sent for forensic analysis.
Yes, that is.
And therefore, the I could have been cross-examined by saying that the weapon did not have a, did not have,
Yes.
this, specks of blood,
Yes.
and therefore it was not sent. So doubt could have been created that this was not a weapon of assault.
In the Caesar list also it is not says that the weapon was bloodstained.
Hmm.
That is not.
That's not there. Yes, Mr. Sharma.
Already after the incident took place, the accused went to the police station first and lodged an FIR. But that was not registered by the police. And where he saw some injuries in his body, that was also not recorded. At that point, we have cross-examined the IO. Page 40. I recorded the statement of the accused person in police station. I caused examination of the accused as per law, medical officer. And I collected the medical report of the accused, where it reflects that he received some injury on the waist. On the top of the spot.
Because you see page 41, about 6 lines from below, it is not a fact that before filing of the present FIR, there was an ejar lodged by Moneshwar Das,
Yes,
which I refused to accept. So he denies that.
yes. Yeah, he denies, but the accused filed an FIR.
No, this is what he's saying, but there's a denial that no such FIR was filed.
Yes,
That's what I'm-
because we are not able to prove that we filed the FIR because we were in the custody. But it appears that the accused also got some injuries when he was medically examined.
Where is that?
On the top of page 41,
Page 41.
yes. PW2 before that the accused, no, sorry. Page 40,
41.
41. Page 40, sorry.
PW2 has not stated before me that accused asked his wife so and so You not stated
No,
this,
40, you know, also can you see, is 40.
40, okay.
On the top. I recorded the statement of the accused person and the police.
I caused examination of the accused as per law through medical officer.
Yes. And I collected the medical report of the accused, where it reflects that he received some injury on the
On the
waist.
waist.
There was a scuffle between the two parties.
The Monester Das. Sorry, please. Yes, injuries there. Injuries there. It's okay. Okay. But Mr. Sharma, this the injury on the accused person will show that there was some scuffle. But how you are benefited out of that? I'm asking you this question for a reason. Because insofar the evidence of PW1 is concerned, her evidence is to the effect that you ask your wife to bring that weapon from the home. It was bought and then he assaulted. So even if there is a scuffle and you got injured by it, the unimpeachable evidence is to the effect that this weapon was bought by you. And then from that you suffered an injury. So if this scuffle takes place, it would only amount to defense, if any, by the deceased. Because there is you see there because this I'm saying this because of a sequence of events. Number one, not only one person was killed, but the other got injured. So two people got injury and then one died, and because of that, assuming that you had that injury, how does it benefit you? Because on principle you are right that the prosecution must explain the injury caused on the accused person. But what happens if there are two accused persons, one of whom died and one is alive and gives a statement that you assaulted? Because unless there is a defense evidence, the fact that you got injury in the same scuffle is also not evident.
On the same day, I went, after the incident, I went to the.
No, I understand. I'm not disbelieving you, Mr. Sharma. But the fact is that if this doesn't come out in the evidence, then because in 313 you said that you will give evidence. It's not a denial that you will not give evidence. But still that yes, injury has to be explained. I'll ask Mr. Das that. Mr. Das, this injury has to be explained. That is the thumb rule.
That is a requirement of law. And unexplained without injury on the defense side. Now that may create some doubt. Now here there are evidence that Madan was already hit. Then Vasudev came to save him. Certainly, there was a scuffle, number one. During that scuffle also, he may receive that injury. And what kind of injury, I do not know. Of course, I have not seen any injury report. Number two, my lord, there is also evidence of the PWs.
It was.
Now, there is also evidence, PWs have stated that when people came, that PW 4, 5, they came because they visited at the time of occurrence, their house due to Bihu. They came, the accused appellant threw the weapon of crime and ran away. During the course of running, you know, also he may receive the injury.
No, it may not be. Just see that flag. It's a green flag. It is in the backside of backside. He got that injury.
Ramesh shoulders. Assault case.
No, in the backside of that page.
Yes,
There's a
yes,
there's
I
a
have got it. Flag mark, green flag mark.
first is the memo. Backside is the doctor's.
So,
Manasar Das.
yes, the assault case and trauma in the Alistair injury.
That word I could not read.
Back and mild stab injury.
Injury at this place I couldn't read. Injury at right.
Yes. Right loss. Injury in right loss. So such type of injury may be received during the by way of falling also. At the time of
Backside.
accident.
Backside you won't fall when you are running.
Maybe mirror, yes, because
Backside injury while running you will only get when you are when you have an injury in the front
or
side
during
also.
the
You will have to fall down. What you call what is it called? Lacerated wound, or say soft injury in the skin. Then you turn over and then maybe perhaps. But
that so
that's not possible.
injury is received. I don't deny that whatever injury may be. And during the
Because when I was child, I was not so good as I am today. Used to fall down hundreds of
100
times. But while running, never I had an injury in the back.
Now, this is one aspect. Number two.
Hello there.
Now, who is the
Injury in the back will not be there. So we get an
No,
advantage
the
even when
injury
we are
in
not good.
right loss? Right loss means below
I just couldn't read that.
back and mild stab injury in right loss. Right. I have understand.
What would be the spelling? LO?
LOICE.
No, there's nothing equal to it.
my lord.
There's nothing near to it.
That is why something different is shown here. I don't know why the medical term. Maybe we have to see.
No, Lois is something I don't know.
Medical dictionary has to be seen.
No, there's nothing called Lois.
Lois is there, but that indicates something else. Below.
No, Lois is in English something which you what you call you brag about success.
Destiny, hearts, desire, and personality. That's what I mean.
Means like you are a successful lawyer,
Yes.
but you will then to show off your success you will come in Mercedes.
Right.
That is showing your displaying your wealth. That is something almost similar to it is Lois.
Medical dictionary as an English. I'll see the meaning. I have one small medical
No, I
dictionary.
have a
of
medical
course.
dictionary. It's here.
Trauma in the left of back.
No, the word is not there. Okay, keep that word aside. We'll find it some other time.
Melodies. Now, this is one aspect. So, to answer the query posed by your lordships, that unexplained injury, which was I submit, you know, there is a they may not have noticed the injury. There was a scuffle, admittedly. Situation shows that because one Basudev, the deceased, came immediately after being attacked his elder brother, being attacked by the accused, and tried to save him. And during that process, tried to save him means certainly he tried to protect him by restraining the accused appellant. So there may be a scuffle, and during that course, he might have received the injury. This is one aspect. Now, my lord, another question arises: who is the aggressor? The important question is that who is the aggressor? Aggressor is the my lord, accused person. He was my lord, erecting my lord post.
In his own.
That is his person.
No,
But
that is
he-
there in the sketch map also.
My lord, but the allegation is, my lord, as per Azahar, he protested that don't put here post, put here in your own land. That
No,
means,
own land. The case is that he was putting up a RCC pillar on the boundary.
yes, boundary.
So it is his own land. RCC pillar is within his land and it is on the boundary. So therefore, the objection is that don't put it in the boundary.
He was erecting a post for a concrete house between the boundary of his house and that of mine. Just boundary, the post
On the
was
boundary, yes,
on
on the
boundary.
boundary, huh? That is okay.
So now, what I was submitting, yes, who is aggressor?
Hmm.
Now, look, from the evidence on record, it is clear that both the PW2 and the deceased, none of them were not armed with any kind of weapon. There is nothing to show, even there is no suggestion that they came with a weapon.
Yes.
So, my lord, they are aggressor. And the PW2 only objected to that. They don't put the pillar on the boundary. Therefore, non-explaining the injury on the part of the it is not a serious injury, as it appears from the injury report. There is nothing to show on record that he was hospitalized or he had to be treated as indoor patient. Nothing of that line. So this was a minor injury, and therefore, my lord, it might have gone out of their notice, my lord. Out of notice of the prosecution witnesses. So that non-explanation cannot destroy the prosecution case, my lord. With all respect, I said. Otherwise,
That possible argument could have been that if there is no cross case,
yes,
then there is only one version of the attack.
yes.
If there is a cross case, then the nature of injuries are required to be seen and examined
Yes.
to enable the court to understand as to whether the prosecution has hiding a version.
Yes.
But I think cross cases are necessary there. I vaguely remember, but I can't say for sure. But the principle applies only when there is a cross case.
Even the defense could have brought these things by a cross-examination also, but they need to raise a doubt only. They need to raise a second possibility of second story. But they have failed to do that. They must be able to, by way of cross-examining the witnesses or adducing evidence, they must be able to show that there is a probable second story.
Yes.
They have not done that. And regarding lodging of, as has been argued by my learned friend, that they went to lodge the FIR, but the police did not register it. Number one, the investigating officer has denied that allegation. Number two, well, if he refused, they would have approached the officer in charge, SP. If SP also did not do that, then he could have approached the magistrate, London magistrate, for direction under section 156 to register a case. That is not done.
Because there is a judgment of Supreme Court where it is mentioned that the relevancy of the injury on the accused is more when the grievous injuries are suffered by the accused.
Yes.
Therefore, then it is required to be explained by the prosecution. But here the injuries are not grievous. Simple injuries in this judgment says non-explanation would not be fatal. I think we'll have to rise in 5 minutes because my brother has another
Yes.
division bench.
And your lordship, single bench is also there, I think. So many eyewitnesses below.
So we'll reserve the judgment then.
Mr. A.C. Sharma, Senior Counsel. Assisted by Mr. S. Das, Counsel for the appellant. Also, Mr. B. Das, it will be appealing for the state. The argument is concluded, judgment reserved. You wanted to say anything more in reply? You wanted to say anything?
No matter. I always say that it is not a cool-blooded murder, or it is not a pre-planned murder, and the accused is already in 4 years in the judicial custody.
Okay, not a pre-planned murder.
There I have an answer, my lord. Before that, my lord, I just like to indicate, my lord, what are these four cases, my lord. Item number 1, my lord, is against seizure of 2 trucks. Seizure of 2 trucks, my lord, item number 1. Item number 2, my lord, there is a stone crusher regulation 29/1/2003 that is under challenge. Stone crusher regulation of 29/1/2003 is under challenge. Item number 3, my lord, seizure of limestone and truck. It's not stone, my lord. Rest are stone, my lord, it is limestone. Seizure of limestone and truck, my lord. And item number 4 again, as like item number 2, stone crusher regulation is under challenge. And the closure of crusher unit is also under challenge. So by the same petitioner. So item number 1 and 4 by the same petitioner. 1 is against seizure of 2 trucks, 4 is against stone crusher regulation and closure of crusher unit. So in item number 1, my lord. My lord may peruse my affidavit, my lord. Affidavit filed by the respondent number 4. And page serial is 76, my lord. Internal page 8.
Yes.
It is the notification that is under challenge in item number 2 and 4, my lord. Two is by a separate petitioner, my lord, but 4 the same petitioner as in item number 1, my lord. This notification is dated 29/1/2003. The governor of Assam is pleased to issue guidelines for installation of a stone crushing machine identified as stone crusher within the state. Consequent on the issue of the regulations, no stone crusher shall be installed in the state without obtaining the permit from the government in the forest department. Here, my lord, the manner and method in which, my lord, the stone crusher units are to be opened and operated mentioned, and serial number 17 is the answer to the query that lordships made on the last occasion. Page 77, my lord. 17, clause number 17. Any type of stone entering or leaving the premises of the stone crusher unit, entering or leaving, my lord. The premises of the stone crusher unit shall be governed by the transit TP and transit challan duly issued under provisions of rules. So this is the answer, my lord. Now, my lord, in all of the cases, my lord, I think, my lord, some background of relevant judgments and rules and regulations are required, my lord, because a stand has been taken in item number 2, wherein the challenge is to the regulation is that stone is it's not a forest produce. There are 2 judgments of the Honorable Division Bench and 1 from the Honorable Supreme Court. So that's why we have no authority to regulate stone. That is their precise argument, even while attacking this regulation, my lord.
Jayesh Bhai, Kanti Bhai.
Yes, my lord, I have prepared a written argument along with the, my lord, judgments I will be relying upon.
You have to give a copy to Mr.
I
Saiwala.
have already given copy, my lord, except the, my lord, judgment copy, my lord, that has been mentioned here. Written argument here, sir. Oh, no. At the outset, my lord, I would like to take your lordship to the Assam Forest Regulations 1891. Rule, we call it section, my lord, though it is regulation. Section 3(4).
Yes.
Forest produce includes B, my lord. Forest produce includes the following when found in or brought from a forest, that is to say, serial number 4, my lord. Peat, surface soil, rock, and minerals, including limestone, laterite, mineral oils, and all products of mines and quarries. Then, my lord, if my lord, and then my lord may kindly turn to, my lord, section 34 of that regulation, my lord.
Section 34. No person shall make use of any forest produce.
Because this 3, 4 when you are reading, 3, 4 says forest produce includes the following whether found in or brought from a forest
Forest, yes, my lord. And for that, my lord,
or not.
for that, my lord, I'll be relying on the judgment of T. Gaudavara, my lord, wherein, my lord, the definition of forest has been extended like anything, my lord. Section 34 now, my lord. No person shall make use of any forest produce or of any land at the disposal of the government and not included in a reserve forest or village forest, except in accordance with rules to be made by the state government in this behalf or as provided by the last section of this chapter. D, my lord. Use of forest produce. D, my lord. Regulate or prohibit the quarrying of stone, boiling of catechu and burning of lime or charcoal. So for under regulated way, my lord, quarrying of stone is permissible. It is very much there in the act itself. Regulation itself, my lord. My lord, acts that are prohibited inside a forest, section 25 of the same regulation, my lord. Section 25 says, acts prohibited in such forest. Any person who, clause E, small e, my lord. Clause E, my lord. Any person who quarries stone. So stone is very much incorporated in the regulations of 1891. Now, my lord, in respect of Assam, my lord, this Assam Forest Regulation of 1891 is applicable, whereas for the rest of the country, the Forest Act of 1927 is applicable. In that Forest Act, my lord, 1927, I would like to take your lordship to section 2(4). Because my lord, the judgments of the Honorable Apex Court are mostly in the context of Forest Act 1927.
Forest Act. Forest Act. Forest Act.
1927.
Bear Act. Yes.
My lord, section 2, subsection 4. Perimeter to that of my lord, 3(4) of Assam Forest Regulations, my lord. Forest produce includes, taking your lordship to clause B, the following when found in or brought from a forest, that is to say, serial number 4, peat, surface soil, rock, and minerals, including limestone, exactly identical, my lord. Then, if I may take your lordship to section 26 of the same act, my lord. Acts prohibited in such forest.
Section
26. Act prohibited in such forest. One, any person who G, my lord.
yes.
Any person who's going to G, my lord, queries stone, burns lime or circle or collects or subjects to any manufacturing process or removes any forest produce down below, my lord, shall be punishable with imprisonment for a term which may extend to 6 months or with fine. Then, my lord, section 33. These are just to indicate that, my lord, identical provisions are contained in both the regulations and the act, my lord. 33, my lord.
Yes.
30 also, my lord. 30, power to issue notification reserving trees, etc. 30 C, my lord. 30, the state government may, by notification in the official gazette, C, prohibit from a date fixed as aforesaid the quarrying of stone or any burning of lime or circle or collection or subjection to any manufacturing process. Then 33 again, my lord. 33B. (33B). 1B, penalties for acts in contravention of notification under section 30 or of rules under 32. B, if we start from the bottom top, my lord, any person who commits any of the following offense, namely, B, contrary to any prohibition under section 30, quarries any stone or burns any lime or circle or so and so, or removes any forest produce. So the word stone finds place in the Act of 1927, that is applicable for the rest of the country, and the Assam Forest Regulation 1891. Now, my lord, I'd like to take your lordship, if my lord takes up my written argument, my lord. Page 15, my lord. This is the first judgment of Honorable Apex Court, my lord. Page 15, Mulsan Cheraugi, Divisional Forest Officer, South Kamrup Division versus Mulsan Cheraugi, Jain respondent. Now, my lord, it was in the context of a, my lord, tender. While, my lord, reading down the provisions, paragraph 5, my lord, you can listen. Section 75 was taken note of, my lord, of 1891 regulation. Then, if my lord comes to the last paragraph, the rule in our judgment does not apply to recovery of the amount alleged to be due for failure to carry out the obligations of the tender by proceedings under the Assam Forest Regulations 1891. There is no clear finding, my lord. It is again difficult to hold that stone is forest produce within the meaning of the act. My lord, following this, my lord, division bench of this honorable court at page 17, my lord. This is a judgment, my lord. Beziram Ingti versus State of Assam. 1980, it was decided on 7/9/1981. If I may take your lordship to paragraph 6, my lord, I would
Page.
page 19, paragraph 6. The next question is whether stone is a forest produce. The expression forest produce has been defined in section 3(2) of the regulation. The question as to whether stone is a forest produce as contemplated under the regulation came up for consideration before the Supreme Court in the Divisional Forest Officer versus Mulsan Cheraugi, the last judgment I pointed, my lord. The Supreme Court has held that it is doubtful whether stone is a forest produce. We extract the exact words used by their lordships in Mulsan. It is again difficult to hold that stone is a forest produce within the meaning of the act. The view expressed by their lordships is binding on us, and in fact, the division bench of this court bound as it was followed the law in Panesar Das versus State of Assam, so reported so and so, we are therefore constrained to hold that we are in great doubt as to whether stone is a forest produce or not. We wonder how, notwithstanding the decision of Mulsan, the state has remained silent as a star and immobile. Why has it failed to recast, change, or amend the definition of the term forest produce in the regulations? It follows therefrom that the state has accepted that stone is not a forest produce and the meaning of the word requires no reformation. So we find no amendment in section 3(4) of the regulation. Under these circumstances, we are confirmed that stone is not a forest produce. Honorable Supreme Court doubted, my lord, while following the division bench confirmed, my lord. We do not propose to paraphrase the definition as the point has been concluded by the authoritative pronouncements just alluded. Therefore, once we hold that stone is not a forest produce, invariably it leads to the conclusion that the provision of section 75, the regulation cannot be applicable in respect of settlement of stone query. Section 75 of regulation reads as follows. Then, my lord, there is a judgment of Patna High Court, my lord, page 23. Herein at my lord, paragraph 7 at page 26. The two judgments referred to above, my lord, were taken note of. Last line, my lord. The apex, para 7 at page 26, my lord. Last sentence, my lord. He has also relied upon the decision of the apex court in the case of Divisional Forest Officer, South Kamrup Division, Guwahati, and the Mulchan versus Mulchan Saraogi reported in so and so. On the same point, the decision has been followed by the Guwahati High Court in the case of Bejiran Ingti versus State of Assam, which is reported in AR so and so, which has also been relied upon by the petitioner. This court would find that the facts of the case in Divisional Forest Officer versus Mulchan Saraogi Jain are that the Divisional Forest Officer had invited tenders for purchase of rights in query stone from certain areas. The respondent therein submitted a tender and offered a particular rate. Tender is not so relevant, my lord. But these two judgments were taken note of. And finally, the Patna High Court paragraph 18, my lord, page 32. The submissions that stone is not a forest produce under the Act is not supported by the decision relied upon by the petitioner's counsel. The state government has duly prohibited quarrying of stone by a notification dated so and so issued under section 30C of the Act. The facts leading to the confiscation, section 30C, my lord, I have already pointed out, of the Indian Forest Act, because it is in respect of Bihar, my lord. The facts leading to the confiscation is that the stone chips was being carried by the petitioner's truck from within the forest area. Upon chase, the truck has been intercepted by Nokha police on so and so road, and no valid challan in respect of the stone chips was produced by the petitioner or his driver at the time of seizure of the truck in question. The notification dated 18/9/1968 issued under section 3C of the Act, when considered with the provisions contained in 24B(4) of the Act in the background, that is the perimeter provision to our regulation definition, make it abundantly clear that the fact that the hand-broken stones was being brought from the protected area leaves no room for doubt to consider that the same would come within the expression forest produce. Section 24B(4) of the Act reads as follows. That has been quoted again, my lord. We have already gone through it, my lord. So accordingly, it was not interfered, my lord. Now, my lord, page 34, there is a judgment of this honorable court, my lord, by a division bench. Issue here was, my lord, regarding in the context of my MMDR Act 1957. Paragraph 5, my lord, is the contention of the petitioners, my lord. Mr. So-and-so, paragraph 5, submits that petitioner appellant purchased the stone ballast from the market on payment of cost thereof, and as such the petitioner appellant is neither required to make payment of royalty under the Forest Conservation of 1980, nor under the Mines and Mineral Development and Regulation Act 1957, and the rules framed thereunder by the Government of Assam, that is the Assam Minor Mineral Concession Rules. Referring to notification dated 1/9/2009, issued by the Government of Assam in exercise of powers conferred under 232, 33, 34, 2DH of the Assam Forest Regulation 1861 and clause 16 thereon, which stipulates the rates of royalty on sand and stone payable by various departments, both state and central government, including the respondent railway. Mr. So-and-so submits that railway did not obtain any permit in respect of materials supplied by the petitioner appellant from the forest department. As such, the respondent's railway cannot insist on such forest clearance certificate from the respondent 7 and held up the payment due to the petitioner. It is the contention that the said machine crushed stone ballast was purchased from open market, and the railway ought not insist for the said certificate from the forest department. Mr. So-and-so learned additional AG Assam submits that by way of the notification dated 1/9/2000, my lord, may I pause for a moment, my lord? If my lord perishes the notification for a moment, my lord, it will be more clear. It is in the Assam Forest Regulations, my lord, that book itself. Before proceeding further, my lord, let us have a look at the notification. In that book, my lord, it should be page 53. Page 53.
Yes.
1st of September 2009, it was issued in exercise of powers conferred under section 32, 33, 34, 2D and H of the Assam Forest Regulations 1891 and its amendments. The governor of Assam is pleased to publish the following schedule of rates of royalty leviable on all classes of forest produce in Assam. If I'm to page 62. Same part of the notification, madam. Part of the same notification, sorry. Rates for sand, gravel, and stone. Serial number B. Serial number B, stone, boulder, gravel, broken stone, single 130 per cubic meter. Page 62, my lord. Clause 16, my lord. Rates for sand, gravel, and stone. B, stone, gravel, stone, boulder, gravel, broken stone, single. Well, for the next case, my lord, regarding limestone, my lord, may kindly take note of F, my lord. Limestone 80 per cubic meter. It says, my lord, then clause B, page 63, my lord. How these forest produce, if brought in from a forest, are to be, my lord, regulated. Clause B. Entitled departments, undertakings of the state and the central government shall obtain permits for the above materials from the forest department or on prior payment of royalty, etc. The above rate is exclusive of VAT, income tax, which will be realized as per prevailing rates. This from where this is, my lord, that Salan that was, my lord, issued to them asking for payment of amounts, some penalty. This income tax and VAT came in, my lord. There is a query made at some point of time, my lord, how can we add income tax also? From now onwards, the concerned department undertaking will write to the respective divisional forest officer recommending the names of contractors, agency for issuance of permit against the concerned department.
No, this may not apply to the petitioner. The simple reason being this is a part of clause 20. Clause 20 is, you see, the general terms and conditions governing the issues of permits and etc. for the department's undertakings.
Yes, ma'am.
So it's not applicable for private.
Not applicable. So as of today, my lord, that procuring a minor mineral, there are two stages, my lord. One, my lord, it will be obtained from my leaseholders, my lord. Or else, my lord, in the same lease area, my lord, government can issue permit. The permit is specific to a government contract. So here is a case, my lord, they claim to have obtained it from the lessee. So as in case of, my lord, permit holders, we keep track, my lord, of the materials, how it is procured or whether revenue has been paid or not. In respect of, my lord, lessees, my lord, that is the procedure we follow to keep a check on them, my lord. But we only want the corresponding proof of deposit of royalty, my lord. Anyway, my lord, let us go to the judgment again, my lord. Clause 8, paragraph 8 of the judgment, my lord, page 40. Page 40, my lord, paragraph 8.
Yes.
My lord. Considering the submissions of the learned counsel, Mr. So-and-so, consider the submissions of the learned counsel. Mr. So-and-so wants to project the case of the petitioner appellant that he purchased the said stone ballast from the open market on direct payment, and under such circumstances, it is the duty cast upon the railway to verify the source from which the petitioner appellant procured the same said item, in as much as the petitioner appellant is not bound to trace out whether the vendor of the petitioner appellant had paid the forest royalty. They have claimed that they have procured it from open market. That means from the produce obtained from leaseholders, my lord. Because there are two ways only possible. One is government permit, next is lease, my lord.
No. Open market means open market. We can't give a word which is not there.
No, we are
You
not
see-
giving it any word, my lord.
No.
Assuming open market is the intermediary, my lord. Has to be intermediary, my lord.
No, you see. I live in Khargoli. If you go in the middle of the road, you will find a vendor who's selling sand. Correct? And aggregates.
That is the open market.
That is the open market.
So that vendor has to obtain it from a leaseholder, my lord. Or else it will be illegal procurement of minor mineral, my lord. So a contractor or any private individual, if wants to use minor mineral, he has two ways out, my lord. One is to get if it is a government project, to get a permit from the government. And if it is for his own consumption or any other purpose, my lord, he can procure it from open market. But for open market, my lord, only source is, my lord, from a mining leaseholder. He cannot go, the open market, that intermediary cannot go to the forest or the river and take stone or sand out of it, my lord. That there has to be some legality in obtaining, my lord. On the other hand, if the notification dated 1/9/2009 of the government is considered, we can conclude that stone ballast is a forest produce, and a notification dated 17/6/2000 binds the respondent railway, and for the said reason, clause 13(2.3) was stipulated in the contract agreement, which the respondent appellant is very much aware. The respondent railway is bound to abide by notification dated 17/6/2000. This was the notification by Forest Finance Department, either. And keeping in view the said notification, the security of the petitioner appellant has not been released. In order to get it released, a duty is cast upon the petitioner appellant to at least. In order to get it released, a duty is cast upon the petitioner appellant at least to inform the source from whom it purchased the said materials in order the railway can verify if the materials so purchased by the petitioner was purchased from a source which paid requisite forest royalty as per notification dated 1/9/2009. Considering the same, we are of the opinion that the so-and-so. In fact, my lord, that notification I have also enclosed here, my lord, Annexure E. So in respect of, my lord, government project, that section 1/2009 notification covers, they have to disclose from where they have obtained, my lord. In respect of this, my lord, in respect of petitioner, the crusher unit, they will also have to show from where they have obtained and for to which person it is going.
But Will your argument be acceptable? You see, insofar as the government departments and mining leaseholders are concerned,
My lord.
we can understand that he carries a TP. But what happens if I go to the market, bring it, say, 1 tell of stone aggregate, I'm taking to my house?
Well.
Who will issue me a TP?
That TP will be issued in the name of the, my lord, stone crusher unit. That is the stone crusher regulation, my lord.
You see, what I'm asking is, let us say that
From open market, there is not required because it has already from the stone crusher unit, it has come to the open market. So it is presumed that they have paid. But if I go there, and bring some forest by minor mineral, it has been intercepted, then I should at least indicate that this is my voucher from this place I have purchased it, my lord. For example, my lord, I can steal a television from a shop and I can take it to my house. If I'm caught in the way, I have to show the invoice. Otherwise, I'm a thief. Now, my lord, coming to the Mines and Mineral Act, my lord.
you see, that is why the power of the police to have a roving inquiry is not there. The first and foremost requirement is that there must be a FIR to disclose that there is a theft of a what you call television.
Yeah.
And then when you are caught, we can understand. Otherwise, what would happen is that the police will start walking into every place and ask me question that where you have got this pen. To you, he will ask you where you have got this band.
True, true.
Correct. So therefore, roving inquiry to a police is not permitted. There are judgments of Supreme Court which also says, for example, I have cash with me in my pocket. In my purse, I have a cash. If you ask me how much it is, I don't know. The answer is very simple. If my wife requires it, she just picks up my wallet and takes out the money for her use.
That happens with most of the rich people.
No,
man.
no,
They
not
don't know
that.
How much money they are carrying. my lord.
No, not that.
I at least know how much money I have right now.
No, not that. But I'm telling you, because my source of income is defined. It goes to a particular bank account and then it comes to me. Therefore, what happens with the money I withdraw from the ATM is purely my concern and the family's concern. So it's not a question of having unaccounted money. But what I'm pointing out is that in my purse, if you ask me a question that how much money you have today exactly, I may not be able to say. But that would not mean that the money which I am carrying is an illegal, what you call, proceeds of crime.
True, man. In a different way, my lord. If suppose there is a checking going on, Naka, by police, they have an information that some criminals are moving something. And during that Naka, my lord, police could find out in front of them that a cognizable offense has been committed. For that, my lord, there is no FIR record. That FIR will be registered by the police in himself, my lord.
Correct.
For example, we have seen, my lord, in
Correct. But you
several
see,
cases.
for that, the requirement is when the police goes out for a Naka, or say there is a drug enforcement drive is given, then what is required is that a GD entry is made, received an information from a secret source that what you call the drug will be passing through it, and based on that, he will take a permission from the concerned officer. So if it's a constable, he takes it from the from the officer in charge, who in fact takes it from the inspector. There's a chain, and then what has happened is to be informed. So therefore, there is a cross check. You can't, the police can't say that now I have decided that I will have a checking program in the High Court campus, court number 7 or no, court number 8. Now we have decided to have a checking there. So the satisfaction is to be pre-recorded.
That's why, my lord, these type of cases are rare. So many trucks are flying with stones. 2, 3 are intercepted, my lord. It's not that random. We have intercepted all the trucks, my lord, and they were found without document. In fact, my lord, post seizure, my lord, they were asked to show cause why they have not obtained a license under this regulation. then their license has been closed, my lord. Suspended, closed, my lord. Operation is closed. That is why now they have challenged this 2003 regulation. I'll try to justify, my lord, try to save these 2003 regulations also. Now, my lord, coming to MMDR Act 1957, my lord. And before that, if I may take your lordship to the constitution for a moment, my lord. 7 schedule, my lord. List 7 schedule, my lord, list 1. Schedule list 1, entry 54, my lord. Regulation of mines and mineral development to the extent to which the regulation and development under the control of the union is declared by the parliament to be law by the parliament by law to be expedient in the public interest. So now coming to MMDR Act 1957, my lord. Section 2, my lord. Section 2 says,
Just a moment.
my lord. That declaration under entry 54 of list 1, 7 schedule has been made at section 2, my lord, of MMDR Act. Declaration as to the expediency of the union control. It is hereby declared that it is expedient in the public interest that the union should take under its control the regulation of mines and development of minerals to the extent hereinafter provided. And finally, I would like to actually, my lord, a same subject, a same mineral is also a forest produce, my lord.
Why principle of implied overruling will not?
That was, my lord, precisely argued in that Kumar Stone Crusher unit, my lord. My lord has only, my lord knows that judgment, my lord. Then that judgment, my lord, Honorable Supreme Court said, to the extent of regulation, it is the central government or it is the MMDR Act. To the extent it is a forest produce, it is the forest department, my lord. And interestingly, my lord, forest department under the regulations also, concession rules, this subject of, my lord, stone, this item stone, my lord, is also entrusted with the forest department. So forest department exercises over a item as a mineral, minor mineral, as well as a forest produce, my lord. My lord, 3E of that act, my lord, for 3E. He says, my lord, minor mineral means building stone, gravel, ordinary clay, ordinary sand, other than the sand used for prescribed purpose, or any other mineral which the central government may by notification in the official gazette declare to be a minor mineral. Now, my lord, to the an argument will be made, my lord. In fact, it is a pleaded case also. In terms of section 9 of this MMDR Act, the royalty is only to be paid by the mining lessees, not by anyone else. That is one of the argument, my lord. Section 9, if my lord peruses for a moment, my lord.
Ajay, just a moment. I'm just addressing the other members of the bar. This will take some time. I may not be able to take up other matters. This is going to take some time.
This is what Mr. Sawala said earlier, but you can mention, I'm having a small for review item 6, my lord.
What is the issue?
Issue is, but in one word, my wife made the construction. I made the submission that my wife died, so I am not the owner of the land. So now, since I am having a legal right, my lord, so since I am one of the successors, that if that is done, that will be mine. Some part mistake on our part also, my lord.
Can we take up tomorrow, day after tomorrow?
Maximum it will take 10 to 15 minutes, my lord.
खाली दिन में नहीं। वही वही पर Friday
Fine.
we'll fix it.
Item 6,
Item 6.
obliged.
Due to positive time matter could not be taken up today. This time.
11.
Section 9 of MMDR Act 1957. Madam.
Hmm.
It says, the holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or any law in force at such commencement, pay royalty in respect of any mineral removed or consumed by him or his agent, manager, employee, contractor, sub-lessee from the leased area after such commencement at the rate for the time being specified in the second schedule in respect of that mineral. Section 9 says so, my lord, that the responsibility is on paying royalty is on the mining lessee. So if now my lord, if we come to section 14. Sorry, section 14, my lord. Section 14 says, Section 5 to 13 not to apply to minor minerals. The provisions of section 5 to 13 inclusive shall not apply to quarry lease, mining lease, or other mineral concession in respect of minor minerals. So because minor minerals can be procured on not only by the lessee, by the permit holders also. Permit holders are not lessees. Permit holders are specific to a work, my lord. Permits are issued for government contracts. For example, for construction of a national highway.
No reasons. How can we get? Because
That I will come to, my lord. Rule says so. Rule will justify that, my lord. That is the reason behind, my lord. Major mineral, my lord, beneficiary is not these type of things, my lord. For example, petroleum. For example, other uranium, my lord. These are minerals which are not used by commoners, my lord. These are common minerals used by common people, my lord. That will come to the rule lateral, my lord. Because in respect of my major mineral, there is no scope of issuing a minor mineral permit, my lord. It is to be lease only. For example, Coal India has been leased for coal mining. So nobody can collect coal for a project except from Coal India, my lord.
here it says section 5 not to apply to
5
minor minerals.
5 to 15 minor mineral is not applicable.
Hmm.
Stone is a minor mineral, my lord. So the requirement of section 9 of paying royalty only by the lessee or his agent is not applicable in minor minerals, my lord. Because there are situations wherein, my lord, minor minerals will be used by government contractors for projects. He is not a lessee. His permits are issued on the basis of his requirement for the project. That's why only lessee is not to pay. Others will also have to pay in respect of minor minerals, my lord. Now, my lord, section 15.
Yes.
Section 15, my lord, power of the state governments to make rules in respect of minor minerals. The state government may, by notification in the official gazette, make rules for regulating the grant of quarry lease, mining lease, or other mineral concession in respect of minor minerals. This is relevant, my lord, and for purposes connected therewith. Quarry lease, mining lease, other mineral concession in respect of minor minerals and for purposes connected therewith. So it expands our scope of, my lord, looking after minerals to the end point, my lord, and for purposes connected therewith. Now, my lord, if we come to rule 23, my lord, sorry, section 23.
You are saying that in Assam Forest Department is given vested with the
Yes.
authority. in
Vice civil, my lord, all vice civil. In MMDR minor mineral concession rule, man, 2013 allows, my lord, Forest Department, PCCR is the authorized officer for controlling over these minerals, my lord, including stone. Limestone was earlier with the geology. It was removed from now as minor mineral. It's a major mineral now again. So in respect of stone, my lord, it is the Forest Department under the MMDR Act and the rules frame there under 2013 rules, as well as Assam Forest Regulation 1891, if it is a forest produce.
Section 23.
My lord.
Yes.
Power of the state government to make rules for preventing illegal mining, transportation, and storage of minerals. The state government may, by notification in the official gazette, make rules.
23.
My lord, 23C, sorry, my lord, 23C.
Yes.
The state government may, by notification in the official gazette, make rules for preventing illegal mining, transportation, my lord. Transportation nowhere indicated from which point to which point, my lord. Storage of minerals. Quarries also store minerals, my lord. And for the purposes connected therewith. So there is a sweeping rule-making power to the central government, state government. Though, my lord, for the purposes connected therewith is not defined, it expands our scope, my lord. So, my lord, the aforesaid two provisions, section 15 and 23C, clubbed with the doctrine of implied power, my lord, saves the notification of 2003. It still exists, my lord. In the meantime, that rule came in 2013 rule. You have not framed specific rule regarding query. We have issued a regulation. In the absence of any rule, these two powers also empowers us, my lord, to make executive instruction till a rule is framed. And for that, my lord, purpose, my lord, I would like to take your lordship. This judgment is already annexed here, my lord. Page 44, my lord. Paragraph 18 at page 49, my lord. Paragraph 18. May I read now?
Yes.
Paragraph 18. This is that famous Sikari Basu case, my lord. It is well settled that when a power is given to an authority to do something, it includes such incidental or implied powers which should ensure the proper doing of that thing. In other words, when any power is expressly granted by the statute, there is impliedly included in the grant, even without special mention, every power and every control, the denial of which would render the grant itself ineffective. Thus, where an act confers jurisdiction, it impliedly grants the power to doing all such acts or employ such means as are essentially necessary for its execution. The reason of this rule, doctrine of implied power, is quite apparent. Many matters of minor details are omitted from legislation. As Crawford observed in the statutory construction, if these details could not be inserted by implication, the drafting of legislation would be interminable, would be an interminable process, and the legislative intent would likely be defeated by a most insignificant omission. In ascertaining a necessary implication, the court simply determines the legislative will and makes it effective. What is necessarily implied is as much part of the statute as if it were specifically written therein. An express grant of statutory power carries with it, by necessary implication, the authority to use all reasonable means to make such grant effective. Thus, in so and so, this court held that the income tax appellate tribunal has implied powers to grant stay, although no such power has been expressly granted to it by the Income Tax Act. Similar examples where this court has affirmed the doctrine of implied powers are these. Paragraph 23, my lord. It was in the context of, my lord, 125 CRPC. What I basically wanted to harp on is that, my lord, we have a power under 23C to, my lord, make rules for preventing illegal mining, transportation, and storage of minerals. We have a power to make a rule to prevent all these things, illegal mining, transportation, storage. Also, my lord, rule says, and for purposes connected therewith. So if we want to monitor a thing to prevent mining, transportation, and storage in an illegal manner, my lord, I think the state cannot be questioned for that. Our intention is good, my lord. There are judgments, my lord, wherein Honorable Apex Court has also held, my lord, to trade in mineral is not a fundamental right. That is in a Hinstone case, Honorable Apex Court has also said. They cannot claim it as a matter of fundamental right, my lord, because mineral belongs to the state. Mineral belongs to the state. We are regulating it to get properly regulate it, to use it in a proper manner, my lord. So anybody coming to the court and saying my Article 14 has been violated, I have a right of business under 19(1)(g) is not acceptable when he's dealing in a business of minerals, my lord. As in case of, my lord, liquor, that Kodai distillery case, Honorable Apex Court has said in respect of liquor, it is a res extra commercial. Nobody claim it as a matter of fundamental right. He can at best make out a case of discrimination to invite, my lord, Article 14.
Is it not that you are keeping some area open? You see, you are asserting that you have a right to regulate transportation, to regulate storage. Insofar as regulation, the storage and the transportation is concerned, you don't develop a mechanism of having this, what you call, some sort of authentication from your end, TP or something.
Here, a rules has already been framed by them, but they are not issuing the dealers.
So if you create a mechanism where somebody has to keep a stock statement, then we can understand. Otherwise, you'd be in a pick and choose manner, you'd be regulating it.
My lord.
Under 23C, this rule has been framed. The only thing, my lord, they have to issue the dealer's license. As given here under dealer's license, because you have to maintain everything, my lord, you have to take the challans, everything is there.
Is there. So once they can regulate it like that, then end of the matter.
Yes, we are regulating it. I'm on the query stone crusher, my lord. There is no specific rule for stone crusher, my lord. This is regarding regulation of, my lord, dealers and regulation and dealers rules, my lord. How a dealer will be enlisted, how he will function. It is there, my lord. Regarding stone crusher, our control over stone crusher unit, my lord. We are our insistence on, my lord, proof of procurement of this stone from stone crusher unit. That is where I'm, because they have not challenged this or they have not raised anything.
He's wanting enforcement. When Mr. Savala is producing this, he wants an enforcement. If you can give him a license, end of the matter. Except for the stone crusher matter, other matters will be disposed of.
All are stone crusher, my lord. except my lord, item number 3,
Huh.
all are stone crusher, my lord.
No, they are carrying out transportation business. In your, in this item 1,
My lord.
it relates to the transportation.
Item 1 relates to transportation from a stone crusher, my lord. And here, there I have pointed out, my lord, clause 17 of that notification, which is also again under challenge in item number 3.
No, that's okay. You see, once you have this regulation and you give him a license for transportation
My lord,
and then you regulate it,
my lord.
we can understand. But if you don't allow them to register themselves under you and then you catch them,
Taken, they are already, they may be a registered dealer under these rules of the. Just a minute. They are already registered under Assam Mineral Regulation and Dealers Rule. But there is one more chapter, that is Stone Crusher Unit. Stone Crusher Unit, we have framed the regulation. Under that also they have to comply with.
no, but what I'm asking you is that if things can be simplified, number one, when you have a rule which regulates transportation and you have got in item number 1,
Yes.
either of 2 trucks.
My lord.
So why the petitioners cannot be permitted to apply and get registration as a dealer?
They are
And then-
already, my lord. That is what they are claiming. They are already a dealer.
No.
They have not given us.
No, they have not applied also. Where is your application? That is not an issue, my lord. Issue here is that we don't have any control over the stone crusher unit. That is their issue, my lord. We say we have control over stone crushers. They want that they should be allowed to crush stone without there being any regulation.
The first petition,
Is against seizure of 2 trucks coming out of a stone crushing unit, my lord.
yes.
Second case, my lord, stone crusher
No,
regulation is.
Here the prayer is to forbear from giving effect to the notice.
My lord.
Where is that notice?
Manoj, that is at page 67.
60?
67. 66.
66.
66.
They should make their mind clear, my lord, whether they want to do business with geology department or with forest department, my lord.
No, this is forest department.
No, this is
66
geology department, my lord.
66.
No, not 66, my lord. This regulation is by geology, which controls Schedule X items, my lord. So they are dealing in Schedule Y.
This notification.
Yes, my lord.
You see, under 23C,
Maybe under
No.
23, there are 2 authorities, my lord.
under section 15, the concession rule has been framed. There, my lord, some items has been given to the forest department.
Under that, the geology has no control. My lord, before
they
coming
can-
to that rules, my lord, let us see concession rules of 2013, my lord. That will make everything clear, my lord. Now, instead of laughing, my senior should place the proper law, my lord. He should not laugh at me, man. I may be ignorant.
No, he's
but-
not laughing at you. You're taking a
Directly
hard-
laughing at me, my lord. I may be ignorant, my lord. But that cannot be a ground for laughing at a person, my lord.
No, he's not laughing at you.
I can hear, my lord.
I don't know.
Mines and mineral concession rules, my lord, 2013.
Yes.
Rule 2E, my lord. Rule 2E. 2E says, my lord, competent authority means the Director of Geology and Mining, Assam, in respect of minor minerals as listed in Schedule X. Minor minerals that are listed in X, it is Director of Geology. Or Principal Chief Conservator of Forest and Head of Forest Force in Assam in respect of minor minerals as listed in Schedule Y. Or any other authority specified by any government notification for exercise of powers and carrying out of such functions as specified in these rules. Now let us, my lord, see what are the Schedule X and Y.
Yes,
Schedule X, my lord.
page.
My lord, I'm holding a book actually. Same
Oh,
book.
acha.
Book, I need your number again. My lord, I'll-
This,
it will be there, my lord. I'll point out, my lord. Should be in the last.
X, yes.
Schedule X. Rule 3.1. Rule 3.1 also says, my lord, if it is X, it is director. If it is Y, it is PCCF. Schedule X minor rule at the heading minor rule C, minor minerals for industrial and specific uses. Building stone, including granite. When mixed for purpose, this is to be controlled by geology. Then Schedule Y by PCCF. Minerals, minor minerals for uses other than in industry. Gravel, ordinary clay, my lord, serial number 12, stone.
Stones were used for making household utensils.
Exactly. Not industrial purpose, actually. Not industrial purpose. So they are claiming that they have procured these stones from, my lord, mining lessees of whose leases were granted by PCCF. That means they are acting under Schedule Y. Now they are referring to a schedule, rules that has been framed, notified by last page of that rule, my lord. Additional 6 Government of Assam Mines and Minerals Department. So mines and minerals is confined to Schedule X.
No, you see, Schedule X. This is building stone, including granite. So, what is a building stone according to you?
That I don't know, my lord, but non-industrial purpose is X. Sorry, Y. Industrial purpose is X. Industrial purpose is X. They themselves have, my lord, pleaded that they have procured it from mining leaseholders under Forest Department. That is lease granted by the PCCF in exercise of powers under Section 3.
But what happens, you look at Schedule X and Y.
My lord.
What happens is it is for used as used for, say, for example, construction of building.
My lord. That is why, then it will be Y, my lord.
How?
That is used are industrial and non-industrial, my lord.
No, this is why is defined. You see, number one, gravel buildings export and for bridges, etc. When used in construction of roads, other than mined in large scale for the construction of dam. So why is construction of road? It does not limit construction of buildings, houses. This is you see, this is a revenue, what you call law.
My lord.
Whatever you are prescribing, there must be a specific prescription.
My lord.
In revenue or taxation, you can't tax by implication.
265, Article 265.
So if an article has more than several uses,
That, my lord, I have to take clarification, my lord. But otherwise, my lord, these stone are procured under my lord schedule Y. They are referring to a rule framed by competent authority under schedule X.
There you have a point. But the other.
Apparently, my lord is correct, my lord.
But
Stone
the
used for
other
making
argument would be that if it is not covered, then you can't,
those
and
jurisdictions.
neither of the departments can then tax or realize revenue out of that.
Yes, my lord is correct, my lord. Stone when used for making household utensils, it's very limited, my lord. And why says stone? Building stone, when mixed for the all the tiles, slabs and other decor when mixed. Slabs. Then again, mineral will come.
You take it after 1 or 2 days because
Yes,
we're
my lord.
already out of time.
And I have to also take
Day
instruction.
after tomorrow,
My lord,
day after tomorrow.
My lord, I have another partner matter is going on actually.
Then Friday.
Friday. Okay, my lord will fix it a day after tomorrow, my lord. If need be, my lord will accommodate me for half an hour, my lord.
No, because you see, I have a division bench regularly. Question of accommodation is not there.
By
We-
3:30,
we-
my lord, I'll be free. Definitely, I'll be free.
Because I either keep it on Thursday or Friday.
Thursday will be better, my lord. He will be Friday also. There will be.
Because for this bench, it is same thing.
Yes. Let it be
Every
on
day is
Friday,
a
my lord.
hearing day.
Let it be on Friday, my lord. Then
Every day is a hearing day. So far as I am concerned.
those days are gone, my lord. When we started practice, my lord, in order matters, everybody were all lawyers were, my lord. We'll see what is the order to be passed today. For steps taken, not taken, affidavit file. Nowadays, my lord, these steps, every step, everybody is ready for hearing. My lord.
I won't say that.
People have pardon, hate not. No, no, it is Friday, my lord. Thursday, if I'm not free, my lord, unless it will be listened. It is on Friday.
Mr. G. S. Havda, the senior counsel, assisted by Mr. P. Deka is present. The submissions of Mr. P. N. Goswami, the additional advocate general, for the state remains inconclusive. List on, the list as a parted matter on Friday, 11. Because Mr. Goswami,
My lord.
if you take offenses of smiles and laughs, then I would be the worst court for you to be here.
I'm not getting it, my lord.
I'm saying that if you are aggrieved by smiles and laughs, then I would be the worst court.
I was that time I was agree because of the distraction.
No.
Not at all.
No. You are no, Mr.
I
Sai.
never do it. I never do it.
Because a style of his smile is a takiya kalam for Mr. Saiwala.
The time was vital here, my lord. For me.
Don't be too touchy. A long, what you call, innings to play.
Earlier, my lord, in admission column, my lord, we all lawyers were ready for issuance of rule, my lord.
No, in fact, I have addressed this to the bar a lot of times. You see, what is happening is that if we start hearing at the admission stage, then the part 2 hearings we can't touch.
Exactly.
And second part is that I have an inherent urge to allow the lawyers to make their submissions, irrespective of their
Yes.
status.
True, my lord.
He may be Mr. Saiwala may be a senior counsel, you may not be a senior counsel, but I give an equal opportunity of hearing. And if I curtail that, you must have seen I am at most of the times I am otherwise prepared. So if I restrict the time of argument, then it would not be a good day for the bar.
Too much. In fact, I always tell my colleagues, if a case of mine is dismissed by court number 7, it don't pains me. True, my lord. If we are hard, my lord, then whatever may be the result, we get the satisfaction, my lord.
And typically also this matter in part 2 matters, advocates are not there. In court number 5.
No, here also in part 2 matters, they are not here.
My lord, I would, I told 13 for you. Others were not there.
Correct.
This happens, my lord.
We are trying to, but we don't have a solution. If you can suggest some, we'll welcome it.
My lord.
Senior members of the bar, if they can,
Once, my lord, I just given a suggestion, if I may, I'm allowed to, my lord. But in most of the chambers, my lord, there are 20 to 30 infractions matters pending, my lord. In any vacation, my lord, we lawyers can find it out and place it before the registry, my lord. Because otherwise, in the court record, those are pending cases. Every chamber is having, in my chamber, at least it will be around 30, 40, my lord.
no, it's welcome.
If everybody, my lord, discloses their infractions matters.
No, I'll give a suggestion, the extrajudicial can accept that.
Exactly, my lord. Then
But-
at least we can reduce our, my lord, number of pending cases. my lord.
Correct, correct.
Every lawyer has, my lord. Bench 4
Correct.
matters,
But,
part 2 bench 4 matters, but 50%
no,
are
but,
infractions.
but you see, it's a welcome suggestion. I'll give it to the history.
Right.
They will entertain these applications.
Part 2 bench 4 matters, my lord, usually infractions. Say 60 to 70% are infractions.
Settlement
Correct.
matters mostly.
Mostly
Correct.
settlement matters, my lord.
Settlement matters after the specific time it becomes infractious.
And
There are
some
service
contractual
matters which are infractions.
Hmm?
There are service matters also which are infractions. my lord. No stay in a transfer matter, he was again transferred, my lord. There are so many issues, my lord. If we all lawyers, my lord, place our own pending infractions matters, I think we can reduce our load by thousands, my lord.
Correct, you are right. You're absolutely right. I'll give forward this suggestion. It will take a day to go to the registry because
Yes.
this is something which the Honorable Chief Justice has to do.
My lord.
I can't give a direction myself, but yes, I'll put a word to the registry. It will go to the.
My lord.
During vacation time, my lord, we can definitely find out the pending infractions. matter.
Correct, correct. It's a welcome suggestion.